I request the dignitaries to kindly grace their presence on dais. First, I request my colleague Raghavan Sampathkumar, Executive Director, FSII. Surya Rao, Syngenta, India. Registrar General, PPVFRA. Friends, it is our pleasure to have with us as our chief guest today, Dr. Trilochan Mohapatra, Chairperson, Protection of Plant Varieties and Farmer Site Authority, Government of India, and former Secretary, Department of Agriculture Research and Education, and Director General, Indian Council for Agriculture Research. Friends, it is time to formally welcome our guests on dais. May I now request my colleague Raghavan to do the honors of welcoming Dr. Mohapatra, please. May I request Mr. Surya Rao to welcome Dr. Dinesh Agarwal. Yeah. May I request Raghavan to welcome Mr. Praveen Deshmukh. Thank you, and it's my opportunity to. Thank you. Ladies and gentlemen, and our esteemed guests, we gather here today to mark beginning of our third awareness session on enforcement of IPR in seeds. The previous two editions have been organized in Delhi and Hyderabad. To mark the beginning of this auspicious ceremony of lighting the ceremonial lamp, symbolizing the light of knowledge that guides us in the pursuit of excellence, may I now request our honorable chief guest and eminent dignitaries on the dais to kindly light the ceremonial lamp and formally inaugurate the session. Thank you. Ladies and gentlemen, as you agree, the robust intellectual property rights environment is crucial for the India seed sector as we strive to become a Viksit Bharat by 2047. IPR protection is critical in accelerating new technologies and innovation needed for faster growth of agriculture. When the innovators are confident of their rights, they are encouraged to invest more. Effective enforcement of IPR in seeds is essential to sustain transformation of agriculture, and that is precisely we are here in Maharashtra, the state where much of the country's seed production happens. With this, may I now request Mr. Surya Rao to kindly do the honors of setting the context for today's discussion. Surya.
Good morning, all. First of all, I want to thank the Chairperson and then the Registrar General and Quality Control Head, Dr. Deshmukh, for accepting our request and attending this one. I want to thank specifically to Authority because they have conducted several awareness programs to the stakeholders. Stakeholders specifically applicant holders like industry or maybe universities and then farmers. But this is a different kind of awareness program where we want all the enforcement authorities also supposed to be there because we get a rights, but while educating those rights, we are facing at the ground level some issues. In this context, we are very much thankful to the present Chairperson and Registrar General because they have changed this normal awareness to the stakeholders, to the enforcement authorities, where we can enforce our rights because mere getting a certificate is not useful unless we enforce our rights at a ground level. So for the last 1 year, I really thank on behalf of industry, sir. We are very much happy the progress what authority has brought and then very much transparent with the time bound. You know that over the last 10 years we are working the time bound things, but I can assure one of the applicant. So now it is a very fast and then they are rushing us to give a reply so that they want to close the application, whether it is a process or maybe the closure. So I really thank you, sir. The transparency you brought in the authority. And then now, why I am specifically mentioning it, any investor, by putting an application, we have to pay a fee. And then if you don't get, we are not sure that when we will get a registration certificate. So there is no sense for any management or maybe then a company to invest on the applications. So from that angle, now the industry, particularly if I can say that from the on behalf of FSII, the industry is very positive to bring more application to the authority so that we can get certificates at earliest time and so that later we can enforce our rights at the ground level. So this is the second session, if I can remember, third session. One we conducted at Delhi to the stakeholders. Second, we conducted at Hyderabad, I think last year. So Hyderabad session was really fantastic, sir, where all the police, judiciary, and then Department of Agriculture, all the three people came together and then they have participated there. It was really fantastic session. Similarly, we thought that Maharashtra also, the reason why we chosen the Maharashtra, we cannot conduct the sessions everywhere, like for every province. We have chosen as a hub where we have a seed production. Like for example, Telangana, Karnataka, Andhra, Maharashtra, and beyond that, we want to go further also. So wherever we have a seed production, there we choose, we face a lot of challenges of thefting of the material and all those things. So that is the main reason why we are spreading this awareness program from one province to another province. From that context, we are again thankful to you, sir, for accepting our request and then coming up with such tremendous awareness programs for all the stakeholders, not only the stakeholders, but beyond stakeholders, we are moving towards the enforcement authority. From this context, so today we will discuss about, Raj Ganesh sir also here, what is the provisions in general session, and then Sir and Registrar General and Chairperson will answer our question and answers later in the process of application if we are facing any issues. Beyond that, Department of Agriculture also, Deshmukh sir also joined on behalf of Agriculture. And then I think 15, 16 people also joined from the Department of Agriculture. That itself shows that the interest of the department. Because Maharashtra, we know that is one of the key states in India where we have plenty of crops. Because if you see in several states, we have limited crops, and a particular crop is prominent in that province. Maharashtra is the state we have all, including floriculture, horticulture, and field crops. Every crop is present in Maharashtra. That is the main reason why we have chosen the Maharashtra location for the awareness program. Thank you, sir. Thanks for giving this opportunity. Thank you.
Thank you, Surya, for setting the context for today's discussion. May I now invite Mr. Praveen Deshmukh for the welcome address, please.
Good morning to everyone. Today we are together here for the enforcement of IPR in seeds. जैसे कि अभी सूर्या जी ने कहा है कि महाराष्ट्र अभी सीड इंडस्ट्री में एक लीडिंग स्टेट है और यहाँ पर हम देखते हैं कि यहाँ पे जो भी कुछ कृषि क्षेत्र में जो प्रगति हुई है, जैसे कि हम जानते हैं कि ग्रेप्स में देखेंगे, ऑनियन में देखेंगे, इवन टर्मरिक में अभी महाराष्ट्र फर्स्ट आ गया है और वेजिटेबल सीड्स है। यहाँ सिर्फ हम हमारी लास्ट टाइम एक सेमिनार सीड इंडस्ट्री का ही हुआ था, उसमें बहुत अच्छी तरीके से बताया गया था कि अभी हम हमारा सीड ही अच्छा क्वालिटी का नहीं प्रोड्यूस कर रहे तो हम दूसरे देशों को भी प्रोड्यूस कर रहे हैं। इतने इस पोजीशन में हम आ गए, तो ऐसे सिचुएशन में हमारा देश प्रगति कर रहा है इस क्षेत्र में। आज के कार्यक्रम में सर ये प्रोग्राम यहाँ, ये वर्कशॉप यहाँ अरेंज करने के लिए मैं सभी सेंट्रल गवर्नमेंट को और ऑर्गेनाइज़र को मैं बहुत धन्यवाद देता हूँ कि एक महाराष्ट्र में पर्टिकुलरली पूना जगह पे पूना में वर्कशॉप आयोजित किया है। तो इसमें जो मेन चीज़ें हमारे सामने अभी आ रही है और इसका जो महत्व है कि इसकी क्या ज़रूरत है, तो हम देखते हैं कि जो नई वैरायटीज़ डेवलपमेंट के बारे में या फिर फार्मर्स हुए या फिर प्राइवेट या फिर गवर्नमेंट यूनिवर्सिटीज़ के रिसर्चर्स है, उनके जो राइट्स है वैरायटी के बारे में उनका प्रोटेक्शन भी होना चाहिए, उसका गलत यूज़ भी नहीं होना चाहिए। और प्रॉपरली जैसे फार्मर्स का आजकल इतना अवेयरनेस बढ़ गया और खेती क्षेत्र में इतनी डिमांड हो गई है कि हमें स्पेसिफिक वैरायटीज़ की डिमांड, जैसे कि हम पहले बोलते थे कि रीजन या फिर सीजन स्पेसिफिक वैरायटी, अभी तो ऐसा हो रहा है कि और भी उसमें सॉइल टाइप हो गया या फिर इवन आजकल हम जो सॉइल के बारे में ऑर्गेनिक मैटर कंटेंट के बारे में तो बहुत ज़्यादा इससे जूझ रहे हैं, उसको भी सभी चीज़ें से जो ये करते हैं उसको मिलके सबको हमको ऐसी जो डिमांड है उसके बारे में भी बहुत ज़्यादा काम करना है। तो आज ये प्रोग्राम यहाँ पे ऑर्गेनाइज हुआ है, तो उसमें अभी गवर्नमेंट अथॉरिटीज़ है, लॉ सेक्टर्स भी है, इवन ब्रीडर्स भी है, तो सभी लोगों को एक जगह पे लाके इसके बारे में अवेयरनेस और बढ़ना चाहिए। इवन मैं तो कहता हूँ कि आगे चल के हम एज अ डिपार्टमेंट फार्मर्स में भी ये अवेयरनेस पैदा करें कि क्या चीज़, इसका क्या महत्व है, कैसे है, उन्होंने फंसना नहीं चाहिए वगैरह ये चीज़ें। तो मैं ये वर्कशॉप यहाँ अरेंज करने के लिए सबको धन्यवाद देता हूँ और इस क्षेत्र में आगे चल के हम अच्छा कार्य करें, इसकी शुभकामना देता हूँ। थैंक यू।
Thank you, Mr. Deshmukh, for your kind address. Now, it is my pleasure to invite Dr. Dinesh Agarwal, Registrar General, PPVFRA, to speak about the PPVFRA Act overview, breeder rights, and the registration stages. Dr. Agarwal, please.
थैंक यू कुलदीप जी, आप सबको मेरा नमस्कार। एंड चीफ गेस्ट ऑफ टुडेज फंक्शन, चेयरपर्सन ऑफ प्रोटेक्शन ऑफ प्लांट वैरायटीज एंड फार्मर्स राइट्स अथॉरिटी एंड फॉर्मर सेक्रेटरी एंड DGICR डॉक्टर त्रिलोचन महापात्रा साहब, श्री देशमुख साहब, हु इज़ द चीफ Quality Control Officer of Maharashtra State Department of Agriculture, Shri Raghavendra ji, who is Executive Director from FSII, Mr. Surya Rao from Syngenta, and Dr. K.V. Prasad Saha, who is here. He is Director of Floricultural Research of ICR. And then there are other scientific colleagues, those who have come from our Pune-based partners, those who are involved in our DOS testing. I welcome them all. And then there are officials. I was told that some 15, 16 officials are there from the State Department of Agriculture. So thank you very much for joining us. And in fact, I would like to thank both FSII and Maharashtra State Department of Agriculture for hosting us here in Pune, which is a very important place. As Kuldeep ji told earlier, that earlier in September we had one sensitization program in Telangana, because most of the seed companies, they are based in Hyderabad. And all the time people were coming to us and asking that there is an effective IPR regime that is available in country, but its implementation, at times it happens to be difficult. Last time हमको बताया था कि सीड कैपिटल हैं और वेजिटेबल में जब भी कुछ चोरी का कंप्लेन होता है पुलिस के पास में या दूसरी जगह जाते हैं, तो जो हैदराबादी लिंगो है, जो जिसमें कहते हैं कि बैगन का बाता, मतलब जो यूजलेस स्टॉक है, दैट इज कॉल्ड एज बैगन का बाता, कि बैगन का चोरी के बारे में हो तो पुलिस में यही होता था कि बैगन का बाता न को करो. तो हमने एक सेंसिटाइजेशन प्रोग्राम किया था ताकि ये बताने के लिए कि बैगन का बाता कुछ केसेस में सच में बैगन का बाता नहीं है. It might involve lot of money. So same way we thought that since Maharashtra is also very important, there are a number of seed companies, that's a very important area for seed production. So we should have a sensitization program here. And in fact, we are not just going to talk about the law enforcement, we are going to talk about the other aspects also. And we are very happy to see the logo there at the top. Shetkarnyancha Sevarth, in service of the farmers. So that is why we are here. Not just for the seed companies, the State Department of Agriculture is there. How together we can serve to the interest of all the stakeholders, which involve private seed companies, public sector organizations like ICR and SEUs, and even the farmers. So, of course, I have a presentation, but my colleague, Mr. Ganesh, who is here, he would be making a presentation about what our act is all about and our general progress. But anyway, before that, I would try to cover. And most of you, those who are from ICR institutes and other organizations and private seed companies, basically you know what this act is all about, what the organization which I am representing before you as a Registrar General basically does. But since हमारे बीच में आज यहाँ पर स्टेट डिपार्टमेंट ऑफ एग्रीकल्चर के भी लोग हैं, शायद आप लोगों का उतना वास्ता नहीं पड़ा होगा हमारे एक्ट से, हमारे संस्था के बारे में, तो मैं आपको बताना चाहूँगा. आपको सबको याद होगा कि 1992 में जब हमने विश्व व्यापार संगठन ज्वाइन किया, वर्ल्ड ट्रेड ऑर्गेनाइजेशन ज्वाइन किया, तो हमारे देश के सामने एक रिक्वायरमेंट था. बेसिकली हमारी इंडियन फिलोसफी हमेशा रही है इंक्लूसिवनेस की, सबकी भलाई के लिए. पर हम मॉडर्न वर्ल्ड में जी रहे हैं जहाँ पर कुछ नेसेसरी रिक्वायरमेंट्स भी होती हैं. तो जब हमने विश्व व्यापार संगठन, वर्ल्ड ट्रेड ऑर्गेनाइजेशन को ज्वाइन किया, तो हमारे सामने एक रिक्वायरमेंट था कि हम प्लांट ब्रीडर्स राइट्स को भी रिकॉग्नाइज करें. चूँकि हम एक डेवलपिंग कंट्री थे, तो हमको 10 साल का समय दिया गया. हमने एक लेजिस्लेशन लेकर के आना था, या जो दुनिया भर में सिस्टम चलता है जिसको यूपो बोलते हैं, इंटरनेशनल यूनियन फॉर प्रोटेक्शन ऑफ न्यू वेराइटीज ऑफ प्लांट्स, या तो हमने उनके बनाए हुए नियमों को ज्वाइन करना था, या अपना खुद का एक कानून लेकर के आना था जहां प्लांट ब्रीडर्स राइट्स को रिकॉग्नाइज करना था. तो जब हमारे पास ये रिक्वायरमेंट थी, तो हमारे पार्लियामेंट ने 2001 में ये जो हमारा एक एक्ट है, जो कि बहुत ही यूनिक एक्ट है. यूनिक एक्ट इन द सेंस ऐसा है क्योंकि आप जानते हैं हमारी जो एग्रीकल्चरल सिचुएशन है, दैट इज़ डिफरेंट फ्रॉम वेस्टर्न वर्ल्ड. हमारे यहाँ बहुत सारी क्रॉप हैं जो हमारी अपनी क्रॉप है, जिसमें हमारे पास बहुत ज़्यादा, बहुत बड़ी, मुझे कहना चाहिए संख्या में, हमारे पास बहुत बड़े नंबर में, बहुत बड़ी तादाद में हमारी एग्रो बायोडाइवर्सिटी है. राइस हमारी अपनी क्रॉप है, मैंगो हमारी अपनी क्रॉप है. आर्बोरियम कॉटन, महाराष्ट्र तो एक इम्पॉर्टेंट एरिया है आर्बोरियम कॉटन का, ट्री कॉटन का, वो हमारी अपनी स्पीसीज़ है. इसके अलावा हम बैंगन की बात करें, बैंगन हमारा अपना क्रॉप है. इनफैक्ट द वर्ड ब्रिंजल, अगर हम उसका इटमोलॉजिकल रूट भी देखें तो भी जो उड़ीसा में संथाल कम्युनिटी है, इट हैज़ कम फ्रॉम देयर ओनली. That is how over the generations, how it became brinjal. So brinjal word का जो origin है, जो etymological अगर आप origin भी देखेंगे तो हमारे हिंदुस्तानी उससे ही निकला हुआ है. Same thing goes for mango. जो mango भी है उसका भी origin अगर etymological root आप देखेंगे तो कहने का मतलब यह है जब हमारी संसद ने when our parliament passed this act, they took into consideration the kind of agrobiodiversity we have and the role of our farmers. हमारे फार्मर्स ने जो हमारी ट्रेडिशनल एग्रोबायोडाइवर्सिटी को सदियों से कंजर्व करके रखा है. और आप सभी जानते हैं जो लोग भी ब्रीडिंग में इन्वॉल्व हैं कि जब भी कोई नई वैरायटी इवॉल्व होती है एग्रीकल्चर के केस में, खासतौर पे वैराइटल रिसर्च के केस में, दिस इज ऑलवेज इंक्रीमेंटल इनोवेशन. कोई चीज़ एग्जिस्ट करती है जिससे या तो हम कोई प्रॉब्लमेटिक चीज़ को निकाल देते हैं या कोई यूजफुल ट्रेड को इंट्रोड्यूस करते हैं. तो हमेशा से ये इंक्रीमेंटल इनोवेशन है और हमारे फार्मर्स ने उस इंक्रीमेंटल इनोवेशन के लिए जो बेसिक बिल्डिंग ब्लॉक होता है एग्रोबायोडाइवर्सिटी का, वो हमारे फार्मर्स ने उसको कंजर्व करके रखा है, अवेलेबल करके रखा है. तो हमने फार्मर्स के कंट्रीब्यूशन को भी रिकॉग्नाइज करना था. ये भी हमारे लिए एक ड्राइविंग पॉइंट था, बड़ा इंपॉर्टेंट पॉइंट था जो हमारे पार्लियामेंटेरियंस ने ध्यान में रखा. इसके साथ में जब ये एक्ट पास हुआ उस समय हमारे यहाँ जो सीड सिस्टम था, आप जानते हैं जो बेसिकली दो तरह के सीड सप्लाई सिस्टम होते हैं, एक फॉर्मल सीड सिस्टम, एक इनफॉर्मल सीड सिस्टम. फॉर्मल सीड सिस्टम में वो सीड आता है जो एक नोन सीड क्वालिटी का होता है, एक नोन डिनोमिनेशन का होता है, एक ऑफिशियल चेन से आया होता है. जो इनफॉर्मल सीड सिस्टम में फार्मर्स जो हैं उनकी ट्रेडिशनल वैरायटीज़ को कंजर्व करते हैं, अपने फार्म पे खुद सीड सेव करते हैं, आपस में एक दूसरे के साथ में एक्सचेंज करते हैं. तो जब 2001 में हमारा ये एक्ट पास हुआ तो बेसिकली हमारी जो लार्जली सीड सप्लाई थी 70 to 75% वो इनफॉर्मल सीड सेक्टर से थी. हमारा जो किसानों के अपना ट्रेडिशनल वैरायटी का और वो जो खुद फार्म सेव सीड यूज करते थे उसका कंट्रीब्यूशन बड़ा होता था. तीसरी चीज इसके साथ में यह है जो अगेन हमें यूरोप और अमेरिका से अलग करती है, जो एवरेज साइज ऑफ लैंड होल्डिंग. एवरेज साइज ऑफ, आप जानते हैं हमारे हिंदुस्तान के केस में जो मोर देन 85% वो स्मॉल और मार्जिनल फार्मर्स हैं, जो रिसोर्स पुअर फार्मर हैं, जो अफोर्ड नहीं कर सकते हैं हर साल इनपुट्स को खरीदना, खासतौर पे सीड को खरीदना. तो ये सारी चीज़ों के साथ में इन सारी कंसिडरेशंस को रखते हुए 2001 में हमारे पार्लियामेंट ने ये एक्ट पास किया जिसको हम PPVFR कहते हैं. मैं फार्मर्स का और बाकी चीज़ों के बारे में उसके बारे में और एम्फेसाइज कर रहा हूँ क्योंकि हमारे बीच में एग्रीकल्चर डिपार्टमेंट के लोग भी हैं. हम सभी स्टेक होल्डर्स के जो इंटरेस्ट हैं उनको यहाँ आज एड्रेस करने के लिए इकट्ठा हुए हैं. तो जब ये 2001 में एक्ट पास हुआ, 2005 में ये अथॉरिटी इस्टेब्लिश हुई. Last year only we have completed 19 years of our existence, and in these 19 years we have ended up with nearly 20,000 applications. 20,000 एप्लीकेशन हैं जिसमें से करीब 8,600, इट इज स्लाइटली मोर देन 8,600, उन एप्लीकेशंस को हमने रजिस्टर भी किया है. और जिस पर्टिकुलर एक भावना के साथ में, एक उद्देश्य के साथ में हमारा ये यूनिक सिस्टम आया था IPR ग्रांट करने का वैरायटीज़ के केस में, आपको जान के खुशी होगी कि एक लायन शेयर 55 से 60% जो एप्लीकेशन है वो फार्मर्स वैरायटीज़ की हैं और हमने उसमें एक उल्लेखनीय कार्य किया है. और आप अभी सूर्या राव जी बता रहे थे कि इस समय जिस तरह से रजिस्ट्रेशन के कार्य में प्रगति हुई है, हमने पिछले 2 सालों में, आप सब उस चीज़ को जानते हैं, जो हमारे बीच में देशमुख साहब हैं और बाकी एग्रीकल्चर स्टेट डिपार्टमेंट के लोग हैं, उनको मैं बताना चाहूँगा कि पिछले 2 सालों में हमने अभी तक जितनी वैरायटी रजिस्टर की हैं उसका नियरली 50% पिछले 2 सालों में हुआ है. और हमारी कोशिश भी है, हम सिर्फ पुराने जो एप्लीकेशंस आई हैं उनके रजिस्ट्रेशन भर का कोशिश नहीं कर रहे हैं. हमारी कोशिश है कि हम साथ साथ और भी जो एप्लीकेशंस हैं, चाहे वो प्राइवेट सेक्टर की हों, चाहे पब्लिक सेक्टर से हों या किसानों की किस्में हों, अगर किसान हमारे पास तक नहीं आ पा रहे हैं तो हम किसानों के पास जाएं और उनकी किस्मों को रजिस्टर करें. तो पिछले 1 साल में, पिछले कुछ बीते सालों में नंबर ऑफ एप्लीकेशंस में कमी आई थी. कुछ इंडस्ट्री के भी इशू थे जिसको हमने इफेक्टिवली रिजॉल्व किया है ताकि अब इंडस्ट्री से भी एप्लीकेशन आनी शुरू हुई हैं. पब्लिक सेक्टर के साथ में भी, हालांकि पब्लिक सेक्टर इज सपोज टू नो ऑल द प्रोविजंस, पर हर बार ऐसा होता नहीं है. पब्लिक सेक्टर में भी अवेयरनेस की कमी होती है. चेयरपर्सन सर के निर्देशन में लगातार हम लोग जाते हैं, यूनिवर्सिटीज़ के पास में जाते हैं, ICR इंस्टीट्यूट्स के पास में जाते हैं, और इसी के साथ साथ पूरे देश में हमने एक मुहिम छेड़ रखी है, क्योंकि हमारे जो KVK हैं आप जानते हैं, हर डिस्ट्रिक्ट में कम से कम 1 KVK तो है ही। बहुत सारे डिस्ट्रिक्ट ऐसे हैं जहाँ पर 2 KVK भी हैं। चूँकि उनका पैन इंडिया प्रेजेंस है, उनका फिटप्रिंट पूरा लेंथ एंड ब्रेड्थ ऑफ द कंट्री है, तो हम KVKs के साथ में हमने ये मुहिम भी छेड़ी हुई है कि हम हमारे फार्मर्स वैरायटी को ज़्यादा से ज़्यादा संख्या में मैप करें और उनको रजिस्टर कर पाएँ। पर चूंकि अगेन फिर से आपको हो सकता है कि एज दे से मे बी आई रन ए हाई रिस्क ऑफ बीइंग बैनल, which is considered to be a modern cardinal sin, that you would not repeat what is obvious, and most of you already know about the provisions. पर क्योंकि आज हमारे बीच में एक बहुत खुशी की बात है कि पुणे में कम से कम एग्रीकल्चर डिपार्टमेंट से बड़ी संख्या में ऑफिशियल्स हैं। तो मैं आपको बताऊं कि हमारा जो एक्ट है, हमारा जो पूरी दुनिया में सिस्टम है, वो सिर्फ नई किस्मों का रजिस्ट्रेशन करता है। पर जैसे मैंने बताया कि हमारे देश में हमारी ट्रेडिशनल एग्रो बायोडाइवर्सिटी बहुत बड़ी तादाद में है हमारे पास में, तो हमारे सिस्टम का ये यूनिकनेस है कि जो विद्यमान किस्में हैं, ऑल दोज वेराइटीज़ विच आर इन एग्जिस्टेंस, उसको भी एक सर्टेन टाइम विंडो में हम रजिस्टर करते हैं, जिसमें फार्मर्स वैरायटी भी होती हैं। और इसी के साथ साथ फार्मर्स का भी अपना कंट्रीब्यूशन है। ना सिर्फ उन्होंने ट्रेडिशनल रेसेस को, ट्रेडिशनल वैरायटीज़ को कंजर्व करके रखा है, बहुत सारी वैरायटीज़ हैं जो फार्मर्स ने खुद इवॉल्व की हैं सिलेक्शन करके, और जो एक बहुत बड़ा, बहुत ही, जैसे मैं अगर बात करूं धान के केस में HMT खोबरागढ़े साहब का एक बड़ी वैरायटी, इसी तरह से तमाम फलों में, बाकी चीज़ों में भी किसानों की बहुत सारी इंपॉर्टेंट किस्में हैं। तो हमारा सिस्टम बहुत यूनिक है इस मामले में कि हम नई वैरायटीज़ के साथ में जो एग्जिस्टिंग वैरायटीज़ हैं उनको रजिस्टर करते हैं। साथ साथ हमारे उसमें, हमारे एक्ट में जो तीनों स्टेक होल्डर्स हैं, हम ब्रीडर्स को उनका राइट ग्रांट करते हैं। एक बड़ा इफेक्टिव सिस्टम प्लेस में है। इसी के साथ साथ रिसर्चर्स के लिए एग्जेम्पशन है। कोई भी रिसर्चर जो इवन रजिस्टर्ड वैरायटी को यूज़ करना चाहता है अपने वैराइटल डेवलपमेंट प्रोग्राम में, until unless he uses it repeatedly, even he is allowed to do without taking any permission. And third thing जो है वो किसानों के अधिकार, किसानों के बीच संबंधित एक विस्तृत अधिकारों की श्रृंखला है हमारे एक्ट में, चाहे वो अपना खुद का सीड बचा करके अगले सीजन में सो करने का हो, या कॉम्पनसेशन क्लेम करने का हो, या उनकी वैरायटी को यूज़ करके किसी ने नई वैरायटी को डेवलप किया हो तो बेनिफिट शेयरिंग का हो। बहुत सारे मेरे कलीग राजगणेश जी जब प्रेजेंटेशन देंगे तो ही विल बी कवरिंग व्हाट एंड ऑल फार्मर्स राइट्स आर अवेलेबल। अब मैं इस उद्देश्य पे आता हूँ कि आज जब हम यहाँ पर आए हैं और जो मल्टीपल पार्टनर्स इकट्ठे हैं, अथॉरिटी है, पब्लिक सेक्टर के रिप्रेजेंटेटिव्स हैं, प्राइवेट सेक्टर से बड़ी संख्या में हैं, FSII ने और NSAI के भी जो दोनों एसोसिएशन से जुड़ी हुई सीड कंपनीज हैं, दे आर देयर, एंड मोस्ट इंपॉर्टेंटली ऑफिशियल्स फ्रॉम स्टेट एग्रीकल्चर डिपार्टमेंट आर देयर। सो हाउ कैन वी कम टुगेदर? जैसा मैंने आपको बताया कि एक इफेक्टिव IPR रिजीम इज ऑलरेडी इन प्लेस फॉर लास्ट 19 ईयर्स। वी आर सर्विंग इंडस्ट्री का जो रिक्वायरमेंट होती थी कि भाई ऐसा ना हो, जो किसी समय में कहते थे टेलीफोन डिपार्टमेंट के लिए कि अगर ग्रैंडफादर अप्लाई करते थे तो ग्रैंडसन को कनेक्शन मिल पाता था, या बजाज चेतक स्कूटर के बारे में कहते थे कि एक लॉन्ग वेटिंग लिस्ट होती थी। इस बीच में कुछ इश्यूज़ के कारण रजिस्ट्री में भी एक बड़ा लंबा समय लग रहा था। रजिस्ट्री में जो एक मेजर डिमांड होती थी जिसको हमने काफ़ी हद तक सॉल्व किया है, और आपको जान के खुशी होगी एट दिस मोमेंट इन टर्म्स ऑफ नंबर ऑफ वेराइटीज़ दैट आर रजिस्टर्ड एवरी ईयर, वी आर नंबर 2 इन द वर्ल्ड। मैं हिंदी में शब्द यूज़ नहीं कर रहा हूँ, दो नंबरी नहीं है हम, बट वी आर नंबर 2 इन द वर्ल्ड इन टर्म्स ऑफ शेयर नंबर ऑफ रजिस्ट्रेशन। ऑफ कोर्स चाइना इज़ फार हेड, पर हम उस गैप को भी कम करने का कोशिश कर रहे हैं। उस गैप को किस तरह से कम करेंगे ताकि हम टेस्टिंग के बाद में वैरायटी हमारे पास ज़्यादा देर पेंडिंग ना रहे। आपकी एप्लीकेशन आती है, हम उसको फटाफट टेस्टिंग में भेजें। सर ने बहुत सारे रिफॉर्म्स लेकर के आए हैं और आप लोग लगातार विजिट भी करते रहते हैं, आपको पता है उन बारे में। तो जो भी फिर भी उसके अलावा भी आपके कुछ कंसर्न होंगे तो जो बात का इंटरेक्टिव सेशन है, हम इंडस्ट्री के उन पॉइंट्स को एड्रेस करेंगे। जहाँ तक एग्रीकल्चर डिपार्टमेंट की बात है, देशमुख साहब आप यहाँ हैं और बाकी ऑफिशियल्स भी हैं। 2-3 इम्पॉर्टेंट इश्यूज हैं जिनके बारे में किसी भी एक्ट का अपनी जगह होना, एक इफेक्टिव IPR रिजीम का अवेलेबल होना, दैट इज़ वन पार्ट। सेकेंड थिंग इट्स इज एनफोर्समेंट। कोई अगर एक्ट है, किसी ने अगर रजिस्टर कराया है तो वो फील्ड पे एनफोर्स होते हुए भी दिखे। जिसमें एग्रीकल्चर डिपार्टमेंट का, सारी स्टेट मशीनरी का, चाहे वो पुलिस हो चाहे जुडिशरी हो, एक बड़ा इंपॉर्टेंट रोल होता है। कई बार जैसे मैं वो बैंगन की बात कर रहा था, तो कई बार होता है कि हम उन चीज़ों से अवेयर नहीं होते हैं। तो हमारा एक ये कोशिश है, जब हम तेलंगाना में गए, यहाँ पर आए हैं, कि जो IPR है वो एक बड़ा इंपॉर्टेंट इशू है। अगर कोई R&D में अपना पैसा इन्वेस्ट करता है और अगर हम उसको एक सेफगार्ड प्रोवाइड नहीं करते हैं, तो अल्टीमेटली वो भी फार्मर्स के इंटरेस्ट में नहीं होता है। फार्मर के इंटरेस्ट में क्या है कि उनको एक बास्केट ऑफ चॉइसेस मिले, उनके पास में तमाम वेराइटीज़ अवेलेबल हो। तो अगर जब तक तमाम वेराइटीज़ अवेलेबल नहीं होगी, बास्केट ऑफ चॉइसेस नहीं होंगी, उनके लिए भी प्रोडक्टिविटी बढ़ना, उनके लिए भी प्रॉस्पेरिटी आना एक थोड़ा सा मुश्किल गोल होगा। तो अल्टीमेटली चाहे पब्लिक सेक्टर हो, प्राइवेट सेक्टर हो, अगर कोई वैरायटी डेवलप करते हैं तो फार्मर्स के ही काम में आती है। तो हमारी सबकी ड्यूटी होती है कि जब IPR रिजीम है तो उसका एनफोर्समेंट फील्ड लेवल पे हो। हमारी जो एनफोर्समेंट एजेंसीज हैं उनके बारे में एक सेंसिटाइजेशन हो कि इस एक्ट में ये प्रोविज़न है, जिसके बारे में मेरे गणेश जी, हमारे कलीग जो आए हैं लीगल एडवाइज़र, वो आपसे बात भी करेंगे। दूसरा एक इम्पॉर्टेंट पॉइंट है जो मैं आपसे स्टेट एग्रीकल्चर डिपार्टमेंट से बोलना चाहूँगा कि सारी कंपनियां वैसे नहीं होती हैं। कई बार आप, जैसे मैं आपको बता रहा था, जो फूड क्रॉप्स हैं, हमारे पब्लिक सेक्टर इंस्टीट्यूशंस हैं या दूसरी और भी कंपनियां हो सकती हैं, उनकी वैरायटी किसी दूसरे स्टेट में उन्होंने बनाई हुई होती है, PPVFR में रजिस्टर होती है। पर जब हम हर स्टेट में, जैसे कि मैं जानता हूँ महाराष्ट्र में आपका एक मैकेनिज्म है, जब आप रिसर्च वैरायटी को सेल करने का लाइसेंस देते हैं, आप ट्रायल्स कंडक्ट करते हैं, एग्रेस को ट्रायल्स होते हैं, वो सारा सब कुछ अच्छा है। पर आज इस पॉइंट ऑफ द टाइम में हमारे बीच में क्रॉस टॉक नहीं है। आपको नहीं पता है कि हमारे पास कौन सी वैरायटी रजिस्टर्ड है, हमें नहीं पता है कि आपने किन वैरायटीज़ को लाइसेंस ग्रांट किया है। तो बाज़ दफ़ा कई बार सिचुएशन ये होती है कि जैसे मैं सोयाबीन की बात करूँ, सोयाबीन इज़ वन क्रॉप जिसमें महाराष्ट्र में सीड रिप्लेसमेंट रेट बहुत अच्छा है। हो सकता है कि वो वैरायटी मध्य प्रदेश में किसी पब्लिक सेक्टर इंस्टीट्यूशन की हो, जो हमारे पास रजिस्टर्ड भी हो, उनके पास उसका IPR ग्रांट भी हो, उनके स्काउट्स महाराष्ट्र में नहीं हैं, उन्हें नहीं पता है कि उनकी वैरायटी यहाँ किसी और नाम से बिक रही है और बिक अनऑथराइज तरीके से नहीं रही है। हो सकता है आपने उसको लाइसेंस भी दिया। तो आज आपके बीच में आने का हमारा एक कारण ये भी था कि दिस इज़ द हाई टाइम। हालांकि नए सीड बिल में इसका प्रोविज़न है, बाकी सारे देशों में एक नेशनल रजिस्टर ऑफ वैरायटीज़ होता है, एक नेशनल लिस्टिंग ऑफ वैरायटीज़ होती है। समहाउ हमारे यहाँ वो चीज़ मिसिंग है। हमारे नए सीड एक्ट में वो प्रपोज भी है, पर अभी तक अनफॉर्चुनेटली सीड एक्ट हमारा पार्लियामेंट से पास नहीं हुआ है। जब भी होगा वो प्रोविज़न होगा। पर क्यों ना हम अपने बीच में क्रॉस टॉक रखें, ताकि हमें मालूम हो कि आपने किन वैरायटीज़ को लाइसेंस दिया हुआ है सेल करने का, और हम भी आपको साथ साथ प्रोवाइड करें उन क्रॉप्स की वो लिस्ट जो हमारे पास रजिस्टर्ड है, जिसका टाइटल किसी दूसरे के पास में है, ताकि कोई दूसरा उसको किसी दूसरे नाम से आपसे लाइसेंस ना ले। तो एक ये इम्पॉर्टेंट पॉइंट है जो सारे आपके स्टेट गवर्नमेंट के ऑफिशियल्स हैं, मैं आपको बताना चाहता था। तीसरा चीज़ जो एक और बहुत इम्पॉर्टेंट चीज़ है, जैसे कि मैं फार्मर्स वैरायटीज़ की बात कर रहा था, मैं आपको बता रहा था कि इस समय हम पिछले 19 सालों में हमारे पास वी हैव रिसीव नियरली 20,000 एप्लीकेशंस एंड ऑलमोस्ट 60% ऑफ दैट हैपन्स टू बी अ फार्मर्स वैरायटीज़। तो ये जो फार्मर्स वैरायटी हमारे पास आई हैं, इसका डिस्ट्रीब्यूशन अगर हम देखें तो पैन इंडिया इट इज़ नॉट वेरी यूनिफॉर्म। देयर आर सर्टेन स्टेट्स विच आर फार अहेड, पर उसके अलावा कुछ स्टेट्स हैं, जैसे मैं महाराष्ट्र की बात करूं, हमारा जो टोटल एप्लीकेशंस है उसका 1/10 महाराष्ट्र से है। Maharashtra so far has filed nearly more than 1750 applications, which happens to be nearly 1/10 or 1/11 of total number of applications, which is perfectly all right. पर अगर मैं फार्मर्स वैरायटी की बात करूं, हमारे पास फार्मर्स वैरायटी का करीब 12,000 एप्लीकेशन आई हैं। उसमें से अगर महाराष्ट्र का शेयर देखें तो दैट हैपन्स टू बी वेरी पैथेटिक, ओनली 210 एप्लीकेशंस आर देयर। तो वो एक एरिया है जहां पर एग्रीकल्चर डिपार्टमेंट और PPVFRA हम साथ में आ सकते हैं। एक बड़ा इंपॉर्टेंट एरिया होगा, क्योंकि आप लगातार आप आत्मा में और भी दूसरे प्रोग्राम्स में फार्मर्स की ट्रेनिंग करते हैं। पूना में हमारा ब्रांच ऑफिस है, शायद आपको जानकारी होगी। हमारे अथॉरिटी के पूरे हिंदुस्तान में 5 ब्रांच ऑफिसेज हैं और उनका एरिया ऑफ ज्यूरिडिक्शन डिफाइंड है। वेस्टर्न इंडिया के लिए हमारा ब्रांच ऑफिस पूना में ही है। मेरा कलीग यहाँ पर बैठा हुआ है डॉक्टर चौहान, तो मैं उसको भी बोलूँगा, यहाँ पर आशीष, हमारे जितने भी ऑफिशियल्स आए हैं, हमने उनसे बात करना है। जब भी उनका आत्मा में कहीं पर भी ट्रेनिंग प्रोग्राम होता है, हमने वहाँ जाना है और जो प्रोसेस ऑफ रजिस्ट्रेशन ऑफ फार्मर्स वैरायटी इज़ वेरी सिंपल, इट्स वेरी वेरी सिंपल। जस्ट 2 पेज का फॉर्म है और हमने स्टेट डिपार्टमेंट ऑफिशियल्स को रिकॉग्नाइज कर रखा है, दे कैन रेटिफाई द फार्मर्स वैरायटी। इनफैक्ट कोई भी फार्मर वैसे एप्लीकेशन हमें एक्सेप्ट नहीं करते हैं, हमारे एक्ट के हिसाब से देयर आर सर्टेन ऑफिशियल्स हु कैन रेटिफाई द एप्लीकेशन, हु वुड सर्टिफाई इट दैट रियली दिस फार्मर हैज़ बीन कंजर्विंग दिस वैरायटी और ही हैज़ इवॉल्व दिस वैरायटी। तो स्टेट जो आपके डिस्ट्रिक्ट एग्रीकल्चर ऑफिसर होते हैं वो उस एप्लीकेशन को रेटिफाई कर सकते हैं। तो ये जो एक अभी तक एरिया है जिसको हमने बहुत इफेक्टिवली एड्रेस नहीं किया है फार्मर्स वैरायटी की मैपिंग का, हम आपके बीच में आज यहाँ आए हैं और आप बड़ी संख्या में हैं, शायद ये एक एरिया है जिसको हम बहुत इफेक्टिवली एड्रेस कर सकते हैं। और इसकी ज़रूरत किस लिए भी है मैं आपको बताऊं, पिछले साल 2024 में आपने नाम सुना होगा वाइपो का, वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गेनाइजेशन। सो दे ब्रॉट वन legal instrument, they facilitated signing of one legal instrument, and India is also a signatory. That happened in May 2024, and what that legal instrument says is that in future if any patent is filed among any of the patent cooperation treaty countries, and mind you there are 159 patent cooperation treaty countries in the world, so in future if any patent is filed among any of these patent cooperation treaty country, and if that patent is based on traditional genetic resource or the knowledge associated with that genetic resource, benefit would go to that country where it happens to be in cultivation in situ, where it happens to be in cultivation, not to a country which is holding it in their ex situ collection. तो हमारे लिए आज बहुत ज़रूरी है, नेचर ने हमको इतना बेस्टो किया है, इतना एग्रो बायोडाइवर्सिटी से, हमारे पास इतनी एग्रो बायोडाइवर्सिटी है। सिर्फ फार्मर्स की उसकी बात नहीं कर रहा हूँ मैं, इवन पब्लिक सेक्टर प्राइवेट सेक्टर की भी जो वैरायटीज़ हैं, हम सब के लिए ये बहुत इंपॉर्टेंट है। अगर हमने बायो पायरेसी को रोकना है, हमारे जो कंट्री के इंटरेस्ट हैं उसको सेफ गार्ड करना है, तो हम ज़्यादा से ज़्यादा संख्या में जितना भी हमारी वेरिएबिलिटी है उसको हम मैप करें, उसको रजिस्टर करें, ताकि टुमारो इफ एनी पेटेंट इज फाइल विच हैपन्स टू बी बेस्ड ऑन दैट जेनेटिक रिसोर्स, एटलीस्ट कंट्री वुड नॉट बी लूजिंग एनीथिंग। तो ये 2-3 चीज़ें थीं जो मैं आपके साथ में शेयर करना चाहता था। चूँकि हम सारे ही लोग अलग अलग सारे स्टेक होल्डर्स आज इस प्लेटफॉर्म पर हैं, तो प्राइवेट सेक्टर भी हमारा ये चाहता है, पब्लिक सेक्टर भी चाहता है कि जो वैरायटी रजिस्टर हुई हैं उसका एनफोर्समेंट ग्राउंड लेवल पे दिखे, जिसके लिए आज हम आपके बीच में आए हैं ताकि हम इस बारे में सेंसिटाइज हों। क्योंकि ये IPR प्लांट वैरायटी के केस में एक ऐसा इशू है जिस पे बहुत ज़्यादा ध्यान नहीं जाता है। इनफैक्ट हमारी कोशिश होती है कि हम पुलिस एकेडमी में, जुडिशियल एकेडमी में, हमारे लीगल एडवाइज़र जो हैं, लास्ट टाइम हमने उनको गुजरात भी भेजा और भी दूसरी लीगल एकेडमी में भेजा, ताकि जो जजेस आ रहे हैं, जो जुडिशियल सर्विस में आ रहे हैं, उनके बीच में भी बाकी सिविल और क्रिमिनल लॉ के अलावा जो IPR से रिलेटेड प्रोविजंस हैं उसके बारे में इंफॉर्मेशन जाए, ताकि जब भी किसी तरह का कोई केस उनके बीच में जाए तो दे वुड बी इक्विप्ड, दे वुड बी नोइंग यस दिस इज़ वेरी इंपॉर्टेंट एरिया। अगर हमने इनोवेशन को प्रमोट करना है, अगर हमने ये कोशिश करना है कि नहीं हमारे फार्मर्स के बीच में नई नई वैरायटीज़ आएँ, तो इसमें हमारा ये ड्यूटी होता है कि वी शुड नॉट रिमेन ए टूथलेस टाइगर, है ना। जब तक हमारे दांत दिखेंगे नहीं, जब तक फील्ड पे ग्राउंड पे दिखेगा नहीं कि नहीं ये सिर्फ IPR पेपर पे ग्रांट नहीं हुआ है, इसका इफेक्टिव इम्प्लीमेंटेशन भी है, तो एक वो बहुत इंपॉर्टेंट एरिया है। वी आर अगेन थैंकफुल फ्रॉम अथॉरिटी साइड दैट यू केम हियर इन अ बिग नंबर, और हम सब साथ में मिल करके ही जो हमारे एक्ट के प्रोविजंस हैं उनको इम्प्लीमेंट कर पाएंगे। और जो दूसरी चीज़ें थी, जैसे मैंने आपको कहा कि एक क्रॉस टॉक वाली बात, जब आप किसी वैरायटी को, रिसर्च वैरायटी को लाइसेंस ग्रांट करते हैं, ना सिर्फ आपकी तरफ से, हमारी तरफ से भी कमी है कि हमने कभी आपको इन्फॉर्मेशन नहीं भेजी है। आज हम इकट्ठे आए हैं तो हम आज देर आए दुरुस्त आयत, हम आज से ही शुरुआत करें कि हम आपके साथ में इन्फॉर्मेशन शेयर करें, और आप भी जिन वैरायटीज़ को लाइसेंस करते हैं, क्योंकि एक इम्पॉर्टेंट प्रोविज़न ये भी है कि जब हम किसी वैरायटी को IPR ग्रांट करते हैं तो वी हैव टू सी टू इट दैट एग्जैक्टली नथिंग लाइक दैट एग्जिस्ट इन कॉमन नॉलेज इन पब्लिक डोमेन, इट शुड बी डिफरेंट एटलीस्ट फॉर वन कैरेक्टर। तो जब तक हमें ये पता नहीं होगा कि कौन सी वैरायटी सेल में है, महाराष्ट्र में या वेस्ट बंगाल में या उत्तर प्रदेश में, आई एम नॉट जस्ट टॉकिंग ऑफ महाराष्ट्र, इनफैक्ट ये पूरे देश का ही सिचुएशन है, तो उस केस में वो जो प्रोटेक्शन है वो भी अधूरा है। somebody may change the name and can bring it, It might be being sold in West Bengal or Kerala or Tamil Nadu for that matter. तो ये क्रॉस टॉक का बहुत ज़रूरी है. आज आप हमारे बीच में सीनियर मोस्ट ऑफिशियल आप हैं एग्रीकल्चर डिपार्टमेंट के, तो हमें पूरी उम्मीद है कि हम इस चीज़ को इफेक्टिवली इम्प्लीमेंट करेंगे. दूसरे आपके जो आज ऑफिशियल्स आए हैं उनके साथ में हम ये जो फार्मर्स वैरायटी का मैपिंग का काम है, अगेन आई एम रिपीटिंग माई सेल्फ, हम इस चीज़ को भी आगे लेके जाएंगे ताकि वो हमारे देश के इंटरेस्ट में
है, लेकिन वो किसी का प्रॉपर्टी है. मालिकाना सत्व तो किसान का नहीं है. कोई प्राइवेट कंपनी का हो सकता है, कोई पब्लिक इंस्टीट्यूशन का भी हो सकता है, जैसे अग्रवाल साहब बता रहे थे. कोई सोयाबीन का किस्म जबलपुर यूनिवर्सिटी का हो सकता है. वो जबलपुर का यूनिवर्सिटी को आप जो है रजिस्टर्ड है हमारे पास. अगर जबलपुर यूनिवर्सिटी आपके नाम पर केस करेगा तो आपको सब देना होगा. कल को जो भी रॉयल्टी देना चाहते वो सब देना होगा आपको. ऐसे नहीं बेच सकते हैं आप. अगर रजिस्टर्ड है, हम नहीं करेंगे, कोर्ट करेगा. तो ये वो फ्री नहीं है कि भाई आप जो मर्जी कर लोगे. अगर रजिस्टर्ड है, भारत सरकार का नियम है, हम कुछ नहीं कर सकते. तो इसीलिए इसके बारे में जानकारी होना जरूरी है कि कोर्ट में कोई भी किसी को ले सकता है. पब्लिक इंस्टीट्यूशन प्राइवेट को ले सकता है, पब्लिक इंस्टीट्यूशन दूसरे पब्लिक इंस्टीट्यूशन को भी ले सकता है कोर्ट में. ये खाली प्राइवेट का बात नहीं है. आज इंडस्ट्री का ये आयोजन किया गया है, हम आए हैं, वो बात खाली इंडस्ट्री का कोई इंटरेस्ट की बात नहीं है. बात यह है कोई भी वायोलेट कर सकता है. किसान का किस्म को आपने यूज किया तो किसान को कुछ फायदा दे दीजिए. अगर नहीं देते हैं तो हमारे पास आ सकता है, कोर्ट भी जा सकता है. तो ये सारे जो है राज्य सरकार को ही पता होना चाहिए कि जो फ्रीडम था, भारत सरकार के जो नियम है, इसको कोई गतिरोध करना नहीं है प्रगति में. इसको और चैनलाइज करना है कि प्रगति को और बढ़ावा देना है. तो इससे हमें कोई किसी का कोई प्रॉपर्टी है, जैसे जमीन होता है इसी तरह का प्रॉपर्टी का राइट्स होता है. तो वैरायटी का राइट भी है, वो राइट दिया गया है भारत सरकार के नियमों द्वारा. इसको हमें समझना चाहिए और उसी उद्देश्य से हम यहां आए हैं. तो कोई एक प्राइवेट कंपनी अगर दूसरे प्राइवेट कंपनी का कोई वैरायटी ले लेता है, वो भी इस दायरे में आएगा. ये नियम का कानून जो भी प्रोविजन है उसकी कार्रवाई उसी के तहत होगा. अगर कोई पब्लिक इंस्टीट्यूशन दूसरे पब्लिक इंस्टीट्यूशन में अगर नहीं जानकारी के कारण वायोलेट करता है, किसान को तो हम छूट दे सकते हैं क्योंकि उसके पास जानकारी नहीं था और नियम में प्रावधान है. किसान अगर गलती करता है, जानकारी नहीं था, उसको हम छूट दे सकते हैं. लेकिन कोई सरकारी संस्थान को छूट नहीं मिलेगा. अगर वो बोलता है हमें जानकारी नहीं था, उसके लिए छूट नहीं मिलेगा. तो इसीलिए सबको पता होना चाहिए. ये खाली प्राइवेट कंपनी की बात नहीं है. हम कोई प्राइवेट कंपनी को फायदा दिलाने के लिए यहां नहीं आए. सबको फायदा दिलाना है जिसका अधिकार है. कोई वैरायटी के ऊपर किसका अधिकार है तो है. अगर उसका अधिकार है तो आप उसको वायोलेट नहीं कर सकते. अगर वायोलेट करोगे, जो भी प्रावधान है उसके तहत पनिशमेंट मिलेगा, कोर्ट देगा. हम नहीं देंगे, कोर्ट देगा. तो इसीलिए हम सब जो है जागरूकता फैलाना हमें जरूरी है और अवेयरनेस क्रिएट करना जरूरी है. हर एक जगह जा जाके इसके बारे में बताना जरूरी है. तो इसीलिए हम यहां आए हैं. समय हो चुका है और 11:20 को हमें चाय के लिए ब्रेक करना है. 11 बजे ब्रेक करना था. अब 11:20-15 हो चुका है और थोड़ा लेट शुरू किए थे. ज़्यादा नहीं बात करते, बहुत सारे बातें हैं करने के लिए, पर मोटा मोटी बात यह है. तो आप सबको इसके बारे में थोड़ा बहुत तो आइडिया हो गया कि करना क्या है और क्या चाहते हैं हम. तो भारत सरकार के कानून का पालन कैसे होगा, तो उसके बारे में हम यहाँ आए हैं बताने के लिए. तो ये कोई इसमें पर्सनल एजेंडा नहीं है, किसी को फायदा दिलाना, किसी को घाटा दिलाना उद्देश्य नहीं है. सबको बताना है कि ये कानून है, इसका पालन करना है. तो इसी उद्देश्य से यहाँ आए थे। आप सबको बहुत बहुत धन्यवाद। तो आप सब लोग आए हैं और आगे का कार्यक्रम चालू जारी रहेगा। बहुत बहुत धन्यवाद। नमस्कार।
Thank you, Dr. Mohapatra. We appreciate your immense energy and the kind of commitment we can see when you speak very passionately about the farmers' interest, the seed industry, the importance of IPR. Thank you, Dr. Mohapatra. I now request my colleague Raghavan Sampathkumar to kindly deliver concluding remarks and vote of thanks.
Thank you, Kuldeep. First of all, our biggest thanks is to the Honorable Chairman, PPVFRA Authority, Dr. Mohapatra, the Registrar General, Dr. Agarwal, and to Mr. Praveen Deshmukh for making it today. And of course, our great host, Surya and other colleagues. The biggest thing that we really appreciate as far as both Dr. Mohapatra and Dr. Agarwal concerned is IPR is a very complex matter. But if you listen to these two experts, they will make it easy on the platter. When I'm a layman, so many of us will not have any idea about how IPR and PVP works. So if we keep listening to them, it actually helps us understand what it does. Not to us, not to the company, not to an association like us, to everyone in the country. So being an expert is one thing, but making others understand, big salutes to both of you. So I think in that sense, मुझे खुश है कि the time that all of you are spending today will be very helpful. The purpose of us, with the blessings of the authority and the state government, Deshmukh sir, when we met him yesterday, he was so keen to understand what it does to the state and the economy and the farmers. So we thank everyone involved in this for their blessings and support. And we are doing it for the cause. It's just to ensure that Bharat becomes Vishwaguru. We have to emulate the most successful country, as far as I know, could be possibly Korea. They have that kind of a stature in the international market. Bharat also should attain that stage, or even go beyond that, I would aspire. And we are capable in every sense. हमारे पास talent है, infrastructure है, biodiversity है, and institutions hai, laws, acts, and everything is there. We just need to come together, and this is the first step we have taken in that sense. In fact, the third step, I would say. So I thank the PPVFR authority, the leadership, the chairman, RG, and of course, Mr. Ganesh and other colleagues, the state government of Maharashtra for their excellent support, and our industry partners from NSAI, from the state officials and from the districts, and my able colleague Kuldeep for putting it together, and our leadership also in FSII, and our great supporters, Crop Life Network. So we take this moment to thank everyone, and of course the next couple of hours are going to be extremely useful for every one of you. So thank you very much, and let's move to the next program. Thanks.
Thank you, Raghavan. Friends, we come to the close of the inaugural session. Now it's a time to extend small token of remembrance for this program to our dignitaries on dais. I request Raghavan to kindly hand over a small memento to Dr. Trilochan Mohapatra. Thank you. Thank you, Dr. Mohapatra. Thank you, Raghavan. I invite my friend Onkar Singh from Exxon to kindly give a memento to Mr. Praveen Deshmukh. Thank you, Onkarji. I request Surya to kindly extend memento to Dr. Dinesh Agarwal. I request Raghavan to kindly extend memento to Surya Rao. Thank you. With this, Mr. Vaibhav Kashikar, Executive Director, Ankur Seeds and Treasurer, NSAI. Seems he's outside. Dr. Neeti Wilson, partner, Anand and Anand. Okay, the speakers are outside, it seems. Meanwhile, I request Dr. Nitin Joshi to kindly start with the proceedings of the discussion, and then in the meantime, the speakers can join, because we will have a presentation initially from Mr. Ganesh. We can start with the presentation. Over to Dr. Joshi, please. Okay. Now, since the speakers are here, Dr. Joshi will give kind of welcome the speakers. I request Dr. Joshi to welcome Mr. Ganesh, please. Thank you. Do we have Manisha Negi here? Ms. Manisha Negi? Okay. I request Dr. Nitin Joshi to welcome Dr. Neeti Wilson, please. And next, I request Dr. Joshi to welcome Mr. Vaibhav Kashikar. Thank you. With this, we start proceedings of the session. I request Dr. Nitin Joshi to kindly take over.
Hello. Yeah, it's okay. Thank you, Kuldeep. So, without wasting any time, and as you know, we also have a stop call. Chairperson has also to go out for other people for other meetings. So, in this session on overview of enforcement of plant variety rights, the challenges and opportunities, we will start with a presentation from the legal advisor of Plant Variety Protection and Farmers' Right Authority, Mr. Ganesh ji, and then we will have a panel discussion with our experts. As on the right side, the lady is Dr. Neeti Wilson. She is basically biotechnologist, then she became a lawyer. And then we have Vaibhav Kashikar. He is the executive director of Ankur Seeds. So we have, and he comes from the National Seed Association of India. I represent Corteva, and I am from the Federation of Seed Industry of India. So we have a full-fledged team of industry and authority and legal people also. And of course, the people sitting here experience in this field, and we will have a question and answer session for 30 minutes at the end. So we will start with Ganesh sir. Over to you, sir.
Good morning to everyone, and just our Chairperson sir and Registrar General sir have in detail summarized the operation and provisions of the Act. But anyway, I'll just give a small presentation. Actually, they have isn't my job, but still, plant breeders' right, which is being conferred by the law, is one of the intellectual property right. And totally there are 7 IPR laws in India, of which the most youngest law is the plant varieties law only. And only one thing I want to say to you, Chairperson sir in his speech was insisting about the registration. He told first is registration is very important and thereafter quality assurance. So here also I want to insist with the registration. So if you see other laws, mainly like trademark, copyright laws, where you get the intellectual property right even without registration. But this plant variety law is like patent law where you get the right only upon registration. So in this I can just give you one analogy. If there is a marriage under Hindu Marriage Act, registration is not a form of marriage. A marriage takes place, the fact of the marriage is registered by the registrar of the marriages under the Hindu Marriage Act. But under the Special Marriage Act, if both the husband and wife belonging to different religious communities go and register, there the registration itself is a form of marriage. So like that way, this analogy, why I am saying is, here under the law, only the registration gives the right. Like the Special Marriage Act, where the registration itself is a marriage. The similar way, only the registration gives the intellectual property right. But unlike where in trademarks and copyrights, you get a right already. And only the registration is evidentiary in nature, just like a Hindu marriage. So this point we must keep in mind. And actually, the tribunal has been abolished, and from now on only this plant variety authority is there. And any order aggrieved or whoever is aggrieved with the order of the registrar or authority, it goes to High Court only. Now I'm just saying, what are the varieties eligible for registration? Varieties is new varieties. New variety means it is very simple. A variety which is not yet commercialized or is commercialized for a period of less than 1 year on the date of filing of application, that is known as the new variety. And the extant variety consists of notified varieties under Seeds Act, common knowledge variety and farmers variety. And new variety must satisfy the criteria of novelty, distinctiveness, uniformity and stability. And extant variety must satisfy the criteria of distinctiveness, uniformity and stability. And this is another unique highlight of this act. This not only the variety, but also the denomination. There is a name assigned by the breeder to the variety. That is what we call it as denomination legally. That denomination is also protected. So both the dual IPR protection is there. Not only the variety, even the name assigned by the breeder, a name given by the breeder to the variety developed, that also qualifies for an IPR. So if anybody infringes not the variety, but the denomination, that is also amounts to an infringement. And we are having 5 branch offices, and the branch officers' jurisdiction are this. If the applicant falls within any of the these branch offices, he has to file the application in the respective branch office. But it can be filed directly to head office also. Now we are receiving. This is what the law says, where the applicant has his principal place of business or domicile within the respective jurisdiction of branch office, must file the application there. And there is a provision for dust testing, because in all other IPR laws, if you see, only database examination is done. Even in patent or trademark, nowhere the invention is tested or verified. even in any IPR law. But here the invention is tested on field. The plant variety is tested on field through dust testing method. And that dust testing is field based and multi-location based. And if the law says that if dust testing fails, the special testing can be conducted, that would be laboratory based. And the authority empanels dust institutions, and all the dust centers and our dust test guidelines are notified by the authority in its journal. And this is the maximum dust test fees, which we have notified in the schedule. And special test fees can be separately charged. And dust testing is conducted in case of new variety for 2 crop seasons at 2 locations, and for extant variety for 1 season at 2 locations. And for EDV, dust testing is decided by the authority on case-to-case basis. In case of trees and vines, there is an option for on-farm dust testing by a panel of 3 experts. And this is a provisional protection which Chairperson sir was also highlighting. This is another unique provision which you cannot find in other IPR laws. So from the date of filing of the application till the registration, the interest of the breeder is protected under the law. So if the moment you file an application, you get a provisional protection under the law. So that provisional protection, for availing the provisional protection, you have to file an application against a person who is abusing the interest of your variety. You have to file an application and has to prove before the registrar by facts and evidences that he is abusing your variety. And thereafter, registrar will pass suitable orders. Of course, there are several challenges in enforcing this, because this provision was struck down as unconstitutional by Delhi High Court. And again, we went to Supreme Court and we got a stay. And now the provision is in force. And still, there are certain gray areas. So, Chairperson sir, after identifying this, there are certain things operating. Even our registrar's judgment interpretation was something different. So, to holistically solve all these problems, Chairperson sir has constituted a committee for this, and we are framing a detailed rules and guidelines, and we have invited the views of the stakeholders also, and we will be taking the views of everyone. Already we have taken the views of everyone, and so we are coming out with the detailed rules which will solve all the problems. And here, like any other IPR law, here a variety can be whatever which is meant for registration can be challenged at 2 points of time, one before to registration and after registration. So before registration, we call it opposition, and post registration, we call it revocation. So once a variety is accepted by registrar for registration, it is advertised in the plant variety journal. And within 3 months, if anybody wants to file an opposition, they can file the opposition. These are the 4 grounds of opposition on which opposition can be filed. And here one thing important we have to remember, that once the opposition is filed, the notice of opposition is forwarded to the applicant. And the applicant must file the counter statement within 2 months. If he fails to submit the counter statement within 2 months, the application filed for registration of the plant variety is deemed to be abandoned. And there is a specific judgment of Delhi High Court also on this. So if opposition proceeding is filed, the applicant must be very careful. They have to file the counter statement on time. Otherwise, their application for registration will be deemed to be abandoned. And these are the time limits for in the opposition proceedings, that after counter statement final opposition, they file their evidences. And these are the rights of the breeder. Of course, this right is subject to the farmer's rights. The breeder has an exclusive right to produce, sell, market, distribute, and otherwise deal with the variety. And there is also a researcher's right, that if any registered variety is used by any person for conducting experiment or research, it is exempted. But this researcher's right is for single time use only. For repeated use of the material, the rights of the initial variety holder must be obtained. And plant variety is like a property. Law treats it as a plant breeder's right is treated as a property in the eye of law. So only like assignment and transmission. So if a person has obtained the plant variety right, he can transfer it to other person even while the application is pending, as well as after the application is registered. So plant breeder's rights is both assignable and transmissible, and it is also heritable. That is, if a father is having a plant breeder right, during the registration he expires, his son can very well step into his shoes as a legal heir. So this is the provision. And a registered breeder, once he gets the right extends to the whole of the territory of India. He himself can't exploit it throughout the territory of India. So he can appoint agents and licensees to effectively exploit his plant breeder's right. And there is a provision for an agent and licensee, but the agent and licensee must get registered with the authority. And there is a provision for surrender of registration certificate also. During the period of registration, if anybody wants to surrender the registration, they have to pay the fees, file a form, and then get it surrendered. And law provides here for initial period of registration and extended period of registration. So the total period is 15 years for field crops, and trees and mines it is 18 years. For maintaining the registration, every year the registered bidder has to pay an annual fee, and this is the annual fee which we have notified in the Gazette of India. For notified variety it is flat 2,000. For new variety it is 2,000 plus 0.2% of the sale value and 1% of royalty. For varieties of common knowledge is 2,000 plus 0.1% of sale value and plus 0.5% of royalty. For farmers variety it is only ₹10, and that also the authority itself pays. So farmer need not pay any annual fee. And renewal fee is paid in one lump sum for the extended period of protection. That is, in case of field crops, it is paid between 5.5 year to 6th year of registration. And for trees and mines, it is paid between 8.5 to 9. And so these are the various renewal fee and annual fee. This every year the annual fee must be paid, and the renewal fee must be paid for the extended period of registration in one lump sum. And if there is any error in the register after registration, any name or change of address, that can be changed. And there is a provision for benefit sharing. The opposition here, one important thing we have to remember, this benefit sharing can be filed only by Indian citizens or organizations which have registered or established in India only. So if any genetic material of the claimant has been used in the varietal development, then the applicant can file a claim for benefit sharing, and these are the procedures for filing benefit sharing. It has to be filed in Form PV7 with 10,000 rupees fees within 6 months from the date of publication in PVJ, and there will be the exchange of pleadings and evidence, and then judgment will be given by the authority based on the extent and nature of use of genetic material and commercial utility and demand in the market of the variety. So once the amount of benefit sharing is determined by the authority, it will be deposited in the gene fund, and from the gene fund it will be paid to the claimant. And as I told you, after registration also, during the period of registration, at any point of time a revocation proceeding can be filed. And revocation proceeding, on filing of revocation proceeding, OAIT is issued to the registered bidder, then he can file the opposition, then reply to opposition, then evidence, and then PV17 is filed for hearing, then hearing is done and judgment is given. These are all the grounds for revocation. And this is very crucial point, the farmers' rights. These are the farmers' rights provided under the Act. That is, the farmer can also breed a new variety, and farmer can save, use, resow, exchange, share or sell his farm produce, including his seed of protected variety, in an unbranded manner. So this is very important. A farmer can sell a seed of a registered variety also, but in an unbranded manner, not in a branded manner. If he sells in a branded manner, it may amount to infringement. So registered varieties must be made available at reasonable price and reasonable quantities within reasonable time. This is also one of the rights of the farmer. And farmers are protected from innocent infringement. And if a farmer proves to the court that he was not aware of the existence of the right, then court can't take cognizance against him. So farmers are exempted from payment of any fee. So apart from this act recognizes that farmers are custodians of the genetic resources, and they are custodian and they are the donors of genes for varietal development, and the law is based on this philosophy. And based on this, so whatever the amount we receive from the registered breeders is deposited as annual fee, is deposited into the National Gene Fund, and from the National Gene Fund we confer award, reward and recognition to the farmers. So the Genome Savior Community Award and this Plant Genome Savior Farmer Reward and Farmer Recognition, these are the amount which we are given. And the criteria for award, reward, recognition is the same only. That is, it should have been used, it should have been selected and preserved, and must have been used as a donor of genes in varieties registrable under the Act. And for that we obtain a certificate of donor of genes also. And these are all the endorsing authorities who can certify this certificate. So here the district agriculture officer is also there here, and district tribal development officer is also here. So I kindly request the state government functionaries, even RG sir during his speech, he expressed that the farmers variety registration is low insofar as Maharashtra is concerned. His concern could be addressed by the government functionaries sitting here. They can also endorse the award, reward, and recognition of the Maharashtra farmers liberally. And this is another important farmer right. If a registered variety fails to give expected performance under given conditions, a farmer can file a claim before the authority. And we have notified state agriculture universities as a claim center for filing of claims as a center. And the SAUs are the notified centers for filing this claim. SAUs will conduct an inquiry and submit a report to the authority. Based on this, the authority will take action. And apart from it, there is a community right also. If any communities has conserved any material and that has been used in the varietal development, then the community can also claim for compensation. And there is a provision for compulsory license that any time after the expiry of 3 years from the grant of certificate of registration, if the variety is not sold at a reasonable price, or it is not sold at reasonable quantities, or it is not supplied at a reasonable time, anybody can make an application for compulsory license. Of course, he has to prove to the authority that he will be able to, if seeds are handed over to him, he will be able to produce and meet the demand. And thereafter, the authority will grant him compulsory license. And the money which he earns, he must pay a royalty to the registered breeder as may be fixed by the authority. These are the procedures for there is a provision for revocation and modification of compulsory license also. As I told you earlier, the appeals go to the High Court. Now there is no more tribunal since tribunal has been abolished. So now I directly go into this enforcement of plant breeders' rights. So plant breeders' rights can be enforced in two ways. One is civil remedy is provided and another is criminal remedy. Civil remedy is provided by way of infringement, where you have to file a suit for infringement, that is perpetual injunction restraining the infringer from producing, selling or marketing the registered variety. So infringement can be done, as I told you earlier, it can be filed against use of the unauthorized use of variety as well as unauthorized use of the denomination, or for both also. So infringement can be filed in district courts only. Our law has a provision that ex parte interim injunction can also be granted. And there is a provision for appointment of scientific advisors also. And apart from it, under Civil Procedures Code, in an infringement suit of IPR, you can appoint commissioners, you can conduct inventory, you can take inventory and take seizure of the infringed materials also. And you can also file an application, the seized materials be sent to the authority for conduct of test, and thereafter the authority will send the report in sealed cover to the court, and thereafter the infringement can be decided. So whoever files an infringement suit must keep in the mind, first they have to ask for an ex parte interim injunction, they have to get a commissioner appointed, they have to either take the inventory or seize the infringed materials, and then again another application has to be filed before the court that the seized materials be sent to the authority for conduct of test and compare it with the variety registered. The data is already available with the authority, and the report of the registrar must be forwarded to the court in sealed cover. And not only the identical similarity, even if denomination is deceptively similar and it is being adopted, infringement suit can be filed. And these are the relief in infringement suits. These three important. So you can seize the documents, how much profits he has made. You can seize his accounts, and you can, based on the accounts estimate, you can arrive at this amount of damages. So again, after seizing the documents, then you can, the breeder has an option either to ask for one lump sum or share in the profits. Just here, one more thing I want to say. There is also the infringing varieties can also be seized and preserved in the court. And apart from it, the property of the infringer can also be attached. Property includes bank account, movable, immobile, everything. And now these are the criminal remedies provided under the Act. So generally criminal remedies are usually adopted when fighting against the fly-by-night operators, or we don't know who is committing the offense, or we are forced to fight in the dark. Here one thing we must remember, the main object of the criminal proceeding is only to punish the offender, and main object of the civil proceeding is to get financial compensation from him. And both the penalties, both civil and criminal remedies, both cannot be pursued simultaneously. Though there is no legal bar in the law, As such, plant variety law, there is no legal bar. But generally, if both remedies are pursued against for the same cause of action against the same person, generally courts, what they do, they stay the criminal proceedings till the disposal of the civil proceedings, because civil proceedings determines the ownership and criminal proceedings only punishes the offender. So after the determination of ownership only, the offender could be punished. So that is the logic which the courts have adopted. And there is the right of accused. If once a person is infringement suit is filed, he can file a revocation proceeding, and till the revocation proceeding is decided, the infringement suit he can ask for a stay of the infringement suit in a criminal. If the accused is actually, it's like this way, I'll say to you: if a criminal proceeding is filed against an infringer, he has an opportunity to file a revocation proceeding, and the criminal proceeding will be stayed till the disposal of the revocation proceeding. That is the provision provided in the Act. And that's it. Thank you.
Thank you, sir, for enlightening us about the PPVFR Act regulations and then registration, and also the enforcement part, which we will talk in detail also during our panel discussion. So let's start with a few of the questions which we will take the inputs from our panelists, and then we will also open for question and answer session with the audience. So let me start with Vaibhav first. Like the act is very old and from 2001, and what RG sir said, it's 19 years we have completed. And so we talk about the plant breeders' rights. And so ultimately we are protecting the rights of the breeders, or that means ultimately the varieties or hybrids are getting protected. So my point is whether you see, coming from company perspective, how do you see your, whether you're in the last few years, if you have registered, your varieties got protected? What's your experience, Vaibhav?
Good morning, all. So I would like to thank Dr. Mohapatra sir and Dr. Agarwal sir to give a very nice perspective of PPVFRA Act. I think the breach of varieties is just like the two-wheelers breaking signal every other day across the country. So same way, our materials are also breached across the country. So most of the time we won't be in a position to name who's doing it, who has done what. But yes, our material was being breached. And unfortunately, when we went to the authorities, it was we who need to prove that it was our variety. The one who applied that this variety was not Ankur's variety, he just put one application and he was just okay with that. But after that, the whole work, the money, the time and the energy that we had to give just to prove that this is my own breeding and my own material. So I think these things need to be addressed so that the applicants, they should be motivated to come and further register their varieties under the Act.
Right. So thank you, Vaibhav. Just for we have state officials also. So just to clarify, one point is here variety infringement is the genetics of what he's saying. His variety as such is packed like it's Kashikar varieties packed by Joshi, selling as a Joshi seeds, something like that. It's not like counterfeit or, the denomination what he explained, but mostly this is happening in seed sector. So the research, the efforts, the money he spent, now I am getting the benefit, and and also cheating in a way to the farmers directly. So now my question is with Neeti. So you are coming from a law firm. So how you see, your clients are coming with this kind of challenges, and then you are putting the case as an expert to the authority or in the court. So what challenges you have witnessed in the past? We are discussing this because unless we know the challenges, we can't go for the remedies or solutions in future. Over to you.
Yeah. Thank you, everyone. First, all the people from the Plant Variety Authority FSII and Maharashtra Agriculture Ministry. It's very important that we realize that this form of intellectual property, which has come up under the Ministry of Agriculture, is a legal right. And I think that's somewhere, that distinction is missing when we see with respect to other intellectual property right and plant variety rights. Because we are very emotionally attached to plants or agriculture as such. And thinking from legal perspective, because this is a commercial thing that we are talking about, the first challenge is to recognize that in intellectual property, we are talking about what is your right. So how do you get your right? You get it through a certificate. And under section 24(2), the patent certificate is to be issued by the Plant Variety Authority in whatever manner they prescribe as per the rules. And we have a very nice certificate. It recognizes only one part, clarifies only one part of the protection, which is the denomination. The variety related protection, what is protected for a variety? As per the law, the protection is for distinctness, vishishtita. The other, utility and the distinctness, uniformity and the stability part, they are testing parts. They are only to validate the distinctness. So the protection is for distinctness. And when you look into patents, it is clear in a patent specification that these are the claims which the applicant is making related to the novel feature, because in patents you get inventions which are new. You get protection for newness. In plant variety, you get protection for distinctness. So that distinctness is not clarified in the the plant variety certificate, and that's a major challenge for the courts to actually decide on the claims which comes in front. So this is one major challenge which has been faced in courts already in some cases. And further, request, Mr. Ganesh mentioned that a declaration with respect to the validity of the variety, when forced, whenever there is an opposition or such kind of actions against that variety, which is available in patents. You can file a declaratory suit that it is a valid patent or it is a non-infringement, which is missing. So I think there are a lot of things. The Plant Variety Authority and the Act from 2007, I remember attending the inauguration of the authority, till now has progressed a lot. And we have seen so many things happening. And I believe in India, everything happens for the best. So enforcement part, which is besides the registration, besides litigation, with enforcement, what do you enforce? Your right. And what is your right? Comes from your certificate. So if you go to the police, you go to the local commissioner, you go to the judge, you need to show what is your right. So that clarity needs to come out, which is one of the major challenges.
Thanks, Neeti. So, tough question, Raj Ganesh ji, over to you. So, what do you see, I mean, the feel is that, the breeders' rights are not, protected in a way and or enforced in a way that, or the applicants' breeders are not getting the relief. So, what's your thought? I mean, why this is happening, or why there is a delay in this kind of infringement cases?
Sir, actually, see, intellectual property right is essentially a private right only, and generally say the law is for vigilant and not for the dormant, they say. And actually, while enforcing the intellectual property right, you have to document the case in a very particular manner, and in a very definite and specific manner. You have to document the infringement, you have to collect the evidences, and you have to maintain your registration correctly by paying annual fees and filing the annual fee return forms. The sales figure which you have mentioned in the annual fee return form, and which you are going to present before the infringement court for claiming compensation, must also tally, it mustn't differ. And once there is, I already told that there is a provision for getting ex parte interim injunction also under the law. And there is a parallel provision in Civil Procedure Code that if you are getting an ex parte interim injunction, within 24 hours, you must communicate the entire document and suit papers to the other side. Otherwise, the injunction stands automatically vacated. And so, what I feel is for enforcing the breeders' right, adequate provisions are available. Breeders must make use of these provisions. As I told you earlier also, they must make an application to seize the infringed material and immediately send the material to the authority for conducting dust test, because the data of the registered variety is already available with the authority. They can conduct the test of the infringed material and submit a report to the court, which will be a very clinching evidence to decide the infringement. So what I feel is breeders must effectively use these provisions. That's it. And apart from it also, we are fine-tuning the act by constituting a very high-level committee in which FSII, we have obtained the views of both the associations. So that also we will look into it separately. But apart from this, a breeder must also be aware, because last I will say to you, even many IPRs have been lost because of the carelessness of the IPR holders, like this trademark nylon, gripe water. So these things are common. So IPR is lost by the person holder also. So they must be careful and enforce their rights.
Sir, that's important to understand the challenges, because then we can learn the lesson and we can move forward. We are not asking, why it has not happened, but eventually, I mean, now we see the time when now registrations are coming up, authorities started, we applied, now we have a process where the applicants are getting the registrations. So now the time has come that enforcement has become a necessity, because now question comes up, what we'll do with these 2 registration pages? So, I mean, so that were the challenges, what you listed down. So one of the good thing what the new chairperson, Dr. Mohapatra, has started is about the provisional protection, because when we apply, and you never know, whenever your variety can be, breached and somebody else is selling, you come to know. So the provisional protection is a big weapon to curb the infringement. And I see, we are thankful to Dr. Mohapatra for, taking views of across, including industry, and from industry FSI side also we have the given inputs. So still, since it is at today also he mentioned that it will be coming in a month or so. So it's a good opportunity, good platform for us together to see, or to suggest if we have something, if this August presence can talk about it and add something which might be missing, although we feel that it has been covered. So, but we will start with Raj Ganeshji, so at least he can give a flavor that what you are, seeing the challenges, what actually you are putting in the, to give it a teeth, in terms of provisional protection.
Sir, currently the provision in the Act is not very specific as to what orders the registrar can pass under the provisional protection, and those things are not very clear. And it has been subject of several legal challenges. So only Chairperson, sir, once he assumed office itself, he immediately took this matter on priority. There were several clouded legal issues. One by one we are clearing. We have constituted a committee, and framing rules for provisional protection is also not easy, because you can't draw parallels from other IPR legislation, because this concept is not available in other IPR law or other concept. So because here only the interest of the breeder, as by the existing law, only the interest of the breeder is protected. It is not the right. Right he gets only upon registration. So we have to protect the breeder. We have to protect the breeder against the abusive act committed by the third party. At the same time, if the applicant breeder files a vexatious claim against this third party, the third party must also be protected. So in a balanced way, it has to be drafted and it has to be made time bound. So we have constituted a high level committee, and already FSII member has also presented his views. We are taking it into account all the views holistically, and it will be in a very short matter of time we will finalize it, and it would be a very balanced and rule which will lay out in detail the procedure to be adopted by the registrar, order that can be passed by the registrar. So it will cover holistically every aspect, and then we will get it notified by the ministry in the Gazette, and then there will be specific rules for it, and then I think what you are saying, the teeth for provisional protection will be made available. We are working on it. Yes, sir, that's what I told, sir. Both associations views we have obtained.
No, sir, we are really thankful. You put everybody in the committee. I mean, although your amendment also you are all stakeholders. You are putting in the committee, taking the views. That's a good thing. But we wanted to know because you all people are here. Coming to Neeti, if you have any suggestion regarding the provisional protection.
There's something, Nitin, I would like to add.
Sir, please.
Okay, it's on. So the observation that was made by Madam Neeti about that our certificate that we grant, it only mentions the denomination. So of course that suggestion is well taken, and we would revise the certificate also, but it's not that distinctiveness is not mentioned anywhere. You might be aware that before we grant a certificate, we put the case for publication in our in-house journal that goes by the name Plant Variety Journal, and that also has a statutory status. There we mention the distinctiveness, and not just the distinctiveness, entire DOS character profile is given in that. Of course, that also has a statutory status that we already do, but your suggestion is well taken, and we would revise our certificate also. Thank you. Thank you very
sir.
much.
Thank you, sir. Over to you, Neeti, about any thing which you would suggest for provisional protection.
Firstly, I want to thank Dr. Dinesh Agarwal for the certificate point. I started from science and then went to law, so I completely understand what you're saying, because for me, when I see the certificate, I need to see the application. However, the code doesn't work like that. Even the police doesn't work like that. They want to see a certificate which says what is protected, and I see a denomination. If the denomination is getting abused, that's easy to enforce. From enforcement perspective only, sir. Not technical perspective, registration perspective, everything is perfect, sir. Coming to provisional protection, I believe that, as Mr. Ganesh also pointed out, that it is only the interest of the breeder which is to be protected. And when this matter went to Supreme Court, whether this provision is to be struck out, the court says that only abuse needs to be defined. What is going to be abuse? And that abuse definition, I'm sure, will come in your guidelines. My concern is that the interest of the breeder under the provisional protection has to be protected till when? The term of the plant variety registration is 15 years. We should not be having 30 years of provisional protection followed by the registration and then further 15 years of registration of related rights. So a particular timeline, a suggestion was made in one of our matters, sir, if you remember, that if we can expedite the registration process itself for the matters in which a provisional protection related application has been made, if they are prioritized, because it has been done in trademark matters also, when the court says that no, first expedite that revocation within these many months or so, come back. You have to go back to court saying that. So if something like that can be done, that you expedite the registration process, even if the registration expeditation is not possible, prima facie finding on the registrability of the variety is very important, because it shouldn't be that you are trying to protect the interest of the breeder and the variety's registration gets rejected. So you have a protection for 10 years under the provisional protection. However, ultimately the variety never got registered. So there was no use of any interest. No, there was no interest. So it is required that a prima facie finding on the registrability comes out first before any provisional protection has been granted. And that's why expediting the registration becomes important. And I think from the authority perspective, I believe that they are taking up all the matters very quickly. Sir has been appointing hearings almost every 15 to 20 days whenever it's getting ahead. So you are taking action, sir, but the challenges as and when with time, if we sort them out, I believe that will be more helpful.
Thank you, Neeti. It's a good suggestion. However, I see, like from last year, because I personally do filing and I'm connected with the authorities. So the registration part is moving very fast now. And what RG sir also mentioned, for the last 2 years, we had many registrations coming in, which we haven't seen in previous years. So the registration part is, that is also important. Sooner the registration comes, so we have, I mean, that's the IP, we get it. But the provisional period also, like whether using the molecular markers to, stop sales and other, penalties, like what Ganesh sir was saying. So these may be the effective mechanism. So both are important, getting faster registration and also the provisional protection having a teeth into it. So so I would ask Vaibhav also, what is there any suggestion in this regard?
I think whatever we are commenting is on our past experiences with the authorities, and I'm sure, as everybody is saying, a lot of changes are being happening, which are most welcome. So I think once the abuse is confirmed, done by the third party, by the registrar, so accordingly, registrar should, send a notice for compensation to the parties who have done the abuse. And the compensation can depends on whether the abuse is of one parental line, two parental line, or of stealing of the material. So the industry perspective, I feel, unless and until those who are stealing the materials and infringing my rights, unless they are not penalized financially, this won't can be carried out effectively. Thank you.
Thank you, Vaibhav. So now we are moving for another question, and that is again, like we know that Chairperson sir has also constituted a new committee. So that is regarding the amendment of the Act also, because now it's around 23, 24 years have passed when this Act came in. Now we have experiences also in this regard. So thank you, sir, for initiating this. And I think we have to see, in a way that it will cater the need for next 20, 25 years down the line. So my question is now with the panelists, not about amendment. Amendment of Act is a big picture. Since today our topic is enforcement of IP rights. So I will only stick to this point, how we can strengthen our IP rights. So Vaibhav, I mean, your suggestion, because the Act is going for amendment, if we have any key suggestion, also I will open later for the audience also, if they have, few points, just suggesting that, because it's a good platform, so to address these issues. So what do you suggest that क्या करें कि इसको बेहतर बनाएं?
Sir, I think any act, unless it is inclusive, so unless there are more number of people coming in and getting part of it, so it becomes a self-discipline once the company started participating. I think as an industry, we always look for incentives. So if there can be some incentives for companies coming up and filing under this act, it will be a good step for motivating people to come and be part of the act. Also, the practicability of the law, whatever we are going to come up with, it carries a lot of importance, because a lot of time people feel, okay, registering is just one step, but how we can apply it practically. So the practical approach is one of the most important thing what industry will be looking for. Thank you.
Thank you, Vaibhav. Now it's the same question with Neeti. What amendment you propose particularly for enforcement?
Well, it's too broad a point to propose amendment, but from the limited experience that I have, there are one very, very practical point would be with respect to certified copies for court proceedings. Now, as you are aware that in courts, you require certified copies from the authority. And Ganesh sir is aware that for sometimes we need to follow up a lot, and there are solutions to it also, because yes, I understand some files get misplaced. It happens everywhere in the world, not just in our country. In patent office, there is a system that in case something is misplaced, you provide a copy of your own, and we will certify it for you as long as you are able to show us that it was received by us. So those certified copies are nothing but application documents, something like that, which are very, very menial task if you consider from the authorities' perspective, nothing technical, nothing. So that's a major hindrance from enforcement perspective when we require certified copies. The bigger picture when I see and I have to propose for an amendment, I would suggest for the plant variety certificate term extension. In patents, in several jurisdictions, we have this, that during the processing of the variety or for the invention registration, if the time is taken more than 3 years and the time is from the government office perspective, then whatever additional days are there, that will be added to your patent term. So if your plant variety registration is not completed in time, then that would happen. The reason I propose this, which in our case may not be the case because our term starts only from registration, is because of the extant varieties who are pending for registration, and 14-year term has completed because it didn't move further. So it's a big loss just because it didn't move, the application did not move further. And I have a live example, so I'm not talking something hypothetically. Even for registered varieties, where we have requested for certain documents and the for court proceedings, and the term has got over of the certificate itself, but we have been waiting. So some timelines, some checklines, in Patent Act, in Biodiversity Act also, they have put in timelines within the rules itself, that it will be disposed of within 30 days, within 90 days, within 6 months, things like that. If something like that could be put in for the stages within the actions before the Plant Variety Authority, I think it will really help in enforcement.
Yeah, good suggestions, Neeti. I mean, this is also when it takes time and your registration is over, so you don't have the right further you can't go to court further. So how it can be addressed, because when matter has already been challenged but registration is over. So that's a good suggestion. So do you agree, Ganeshji, with the other panelists, what they're saying?
Sir, actually we have constituted a very high level committee to look into the amendments required in this act, and Madam has suggested that there must be a timeline for issuing certificate copies because otherwise the enforcement of the rights might be get hampered or delayed. That's the concern. And actually we have already requested the views of both the FSII and the NSAI to present before the committee. So definitely we will also place the concerns of the madam, and definitely we will suggest a timeline and we will place it before the committee and we will consider it, sir.
In fact, I would like to respond to the points that have been raised by, again by Neeti. So first of all, maybe in a specific case, they might not have been able to follow a timeline, but to say that in every case timeline is not being followed, probably that would not be fair to authority. We are sticking to timeline. There could be an exception doesn't make rule. So that is one thing that I would like to tell you. We stick to the timeline. Maybe in one or two very, very exceptional case, they might have misplaced the file because you know that we shifted from our old facility to the new one. They might not be able to trace it out. But in general, we follow the timeline. That is one thing. And as far as provisional protection, again, I would not go into individual cases because this forum is not for individual cases. We are discussing in general. For provisional protection also, you know, the gray area has been the way it has been defined in our act. It has been given only in 2.5 line as Ganesh was talking. It was struck down by Delhi High Court. We got a stay in Supreme Court. Now already committee is in place, where again we have drawn members among all the stakeholders. So we are addressing all those issues, and we are also, we want that whatever laws are there, they should be seen to be working. We don't want to work like a toothless tiger. So we are addressing all those issues. There could be specific instances, and I would suggest there are remedies available in other acts also. I'm not going to go into the individual cases, but can understand that. So surely we are working at it, we are at it, and we would provide a solution. Thank you.
Thank you, sir. I mean, the idea is not to pinpoint anything, but the idea is, sir, because now the authority is itself going for provisional protection amendment with the act. So it's a just take it a kind of a suggestion where if the infringement happens, so I mean, like our mobile is being stolen, so how, you know?
No, we
our
took
blood
it. We
pressure
took it
goes
in
up.
we took it in a positive spirit only.
Yeah.
But the only thing is that message should not go that in place. Maybe in a specific case that might not have been followed. But otherwise, whatever your grievances are there, we are always there to resolve those. Thank you.
Sir, because like, let's say when we file, I mean, we are not complaining in that way. When the matter is in the court, now they ask the certified copies, now the next hearing date is decided. So we are also, you know, abide by the court regulations. So the certified copies, I mean, we are saying just to, you know, kind of prioritize in this kind of infringement, where we are also, you know, liable to, because we have applied in high court, let's say, we have to give it back. So that's the thing, and we are, I mean, industry or anybody else is paying for that. So if, you know, for this thing which can be prioritized, what we are saying, not saying it's not happening. We want the priority because the matter is sub judice. And I mean, we are the party and somebody else is taking our variety, selling in the market very, you know, openly, and we are unable to do anything. So that's the thing for which we need your support. And right now, because you are itself doing these amendments, so it's an opportunity for us to share some few things which can be the opportunities, because our today's topic is, we are not talking about the challenges just to hit, just to move forward, and this is our, I mean, ultimate aim. So coming to the last question, you know, like a lot of things are happening, and we are, you know, for enforcement, we are going to the court. What I said, sir, it takes time. Court also, it takes sweet time, you know, in taking a call. So just, I mean, wondering now, Act is revising. So whether the authority, like provisional protection, even after the registration certificate is issued, if some infringement happens, is there any possibility in the amendment, whether I'm wondering if it can be added, and we come to you, sir. We want to come to you. It's nothing like that. So, and you address if there is some mechanism which comes in, and because you all have data, and we are going, you know, court is asking certified copies. Again, we are coming back to you. You are providing you are the resources on which they are also relying. So whether the authority can itself take a call post-registration also. And sometimes what happens, you have applied and then you got the registration. Provisional, then you will say now registration has been issued, now you go to court. So how to settle in these cases? So, I mean, this is my thought. So I'm asking Vaibhav also whether, do you see it's a fair idea, or I mean, it's not having any sense?
See, I think any mechanism that can gain the confidence of stakeholders, confidence just not only to register the material, but also the process post-registration. So I think these are the two very important things. If we are able to address this, any mechanism which will create a positivity among the stakeholders is always welcome and can be very effectively implemented to avoid all the things that are happening in the market today.
So, Neeti, my question is whether you see, you know, like whether any amendment can be done in the Act also, and then we can have this also like provisional protection post-registration.
I don't think legally it would be right to have provisional protection continued after registration. So I believe that there's no question of amendment coming to that. What I'd suggest from enforcement perspective for the industry or the breeders in general, which applies to all intellectual property, not just plant variety, is to think of collaboration. The collaboration in-house between the people who are registering, the breeders themselves, the regulatory team, because they are dealing with so many things related to your variety. Most importantly, your legal team, because, okay, I'll give you an example of my own firm. We have a prosecution team, we have a litigation team, we have an enforcement team, and we come up with a strategy after a collaborative discussion on each intellectual property, whether it is a trademark or a plant variety or a patent, whatever. And those suggestions are given to the applicant or the patent right holder, and they take a decision whether to proceed with litigation or licensing or going to the authority, opposition, revocation, depending on the strategy that is best suited for your company. So from enforcement perspective, the same goes when you are proceeding for plant varieties. If you are not collaborating within teams, same goes from the plant variety authority perspective also. They have a technical team which is doing the registrations. They have a legal team which is taking care of the legal two-party proceedings, and at the same time they need to have a team which understands the enforcement perspective, the awards for farmers, the all the other related activities. I'm not counting on that because that exists in other intellectual property also. Patent office also gives awards to highest innovators and the individual inventors. They recognize them, they give them recognition. That's part of being intellectual property pro organization. So that is important, but at the same time the realization that this is the right which the certificate will endow on you, and then how to use, how to facilitate the certificate holders to use it, because ultimately it's a negative right. You cannot stop anybody, you have to sue them to stop. So that mindset needs to be there.
Thank you, Neeti. So, still, if post-registration we have to go to court, still, if we have filed during the provisional period, so the settlement till the registration certificate is issued, it should be, that part should be covered by the authority also, because infringement has happened that period also, that period, that value, because we are paying annual returns to the authority. So that should be taken care by the authority, and then the rest settlement will happen in the court. So do you agree with this, or you see, any modification can be done in the act, and post-registration also the authority can support their registration, the registrants?
Sir, as far as provisional protection is concerned, it is very clear. It is applicable only from date of filing of application till registration. Post-registration, it is covered only through infringement, and it can be enforced only by courts and police. But still I can say, as I told you earlier again, there are sufficient provisions for appointment of scientific advisor is there. You can request that the authority may be appointed as scientific advisor under section 67 of the Act to assist the court in the infringement proceedings. You can seize the infringing materials, because ex parte seizure is also allowed by the court. You can seize the infringing materials and send it to the authority. You can make an application to conduct, because what I'm saying is it is not a new thing. It has already been done by several seed companies. So you can conduct a seizure through civil court through infringement proceedings. Send the seized materials to the authority. Authority will conduct a test of the seized material and compare it with the dust data of the registered variety, and send the report along with its analysis to the court in sealed cover. So this is already possible. You can involve the authority even now. And in spite of it, still, if you want to involve, is there any specific provision which you want to bring in also, we have already sought your views. Can submit, we will definitely consider it. But still my view is the existing provisions also provide adequate room for involving the authority in post-registration infringement.
In fact, that's a very good suggestion, Ganesh, and I would request, both the associations, they can give, because it's still, it's still early days only. We had only one meeting, and so now we would be going ahead. So if there could be any role for the registry post-registration to settle the infringement cases, those things surely would be addressed. So you kindly submit your suggestions to authority.
Sure, sir, sure. So why I am coming to this point is, sir, like what sir said, collecting the samples. So for example, collecting the samples for a company like Section 3.2.
Exactly
we have
like
to take NB approval.
Yeah.
So it again takes 6 to 9 months. So by the time the season is over, so next season the fly-by-night operators will come with a new name.
Yeah.
Then we will again apply. We will take the approval. So that's a cumbersome process.
Sir, I am not saying Caesar to be conducted by you. What I am saying is there is a provision under the law that you approach the infringing court to get a commissioner appointed. Court will appoint somebody. That person will go and collect the seeds or take the inventory and file a report to the court along with the seized material. So it is done through the court, not by the applicant. There, this NPA, those things will not be applicable. It is done for collection of evidence purposes. So court does it in civil matters. Court has power for it. So there, this NPA, those things will. If you go and collect there, the NPA things will come. So this is only court is collecting it for protecting test. So it is done through the court only. It is an act of the court. So that.
Sir, but getting the evidence that this material is being infringed,
Sir,
you need to collect that material.
Okay, sir, here again I want to say to you, see, in infringement cases proceeds like this way. At the initial stage, judge gives this, passes the order of temporary injunction or orders seizure based on prima facie only. You need not submit or prove before the court. That is done only at the trial stage before he passes an order for compensation. Here he decides in a prima facie manner, like granting bail to the accused or not. He can't go and decide whether the person is innocent or has committed the crime. Just as a prima facie manner, he will decide to grant bail or not. In the similar fashion only, they decide in a prima facie way to do the seizure or not. So this is, it is already been done. Madam will be well aware. It is done in trademark cases, patent cases. So what is the problem here? Several seed companies have obtained order, and the Registrar General Sarah has also presented his report in sealed cover to the I think Aurangabad court, Jalna court, district court. So it can be done.
So that's a good thing, sir, what you said. That means now judges are aware of, that's a, awareness is spreading, you know, among the judges. Because earlier what you said, sir, they say seed can be stolen. So that is the story what you narrated in the morning. Because court judges has to understand about the seed infringement. So with this, I mean, we have discussed the few of the enforcement piece, but now we will be opening up with the audience. If they have any, they can ask anything. I mean, anything means relation to the enforcement of IP rights. And also if you have any suggestion regarding provisional protection or something, what can be amended in the act, especially for enforcement piece, because today we are sticking to enforcement part. So that can be, noted down and we can pass it on to the authority. Yeah, Surya.
Thank you. Sir, it is in continuation of 24.5 what just we discussed. Let us assume that since we have an opportunity to give a comments for the amendment of the act, let us assume that we have a 24.5 in the process. Applicant, I challenged somebody and then committee is working on it. Meanwhile, I got a registration certificate. So till the authority, which is working, whether that is still valid or say that no, you got a grant so that whatever the period, it will be to take action by the authority.
Sir, could you kindly repeat your question, sir?
Sir, we have a 24.5. During
Sir, that is, I got your point. You
Yeah.
are saying that provisional protection is filed for the post-registration for the period from filing of application till the date of registration.
No. Now, for example, I filed an application. Till the time I get a grant, it may take 2 years or 3 years. Okay. Now I challenged somebody under the 24.5. Now authority formed a committee, maybe, and it is in the process of taking action by the authority. Meanwhile, authority not yet taken any decision, but meanwhile, I got a grant of registration. So whatever authority done for this period, since I got a certificate, still whatever
The provision
for the previous action
will continue for the earlier period.
But still the authority have that right after grant of registration.
Sir, for the earlier period, authority will pass a judgment for the earlier period, not
Yeah.
after the post-registration period. From filing of application, your point is that the provisional protection
Period.
application is pending.
Yeah.
In the meantime, you got a registration certificate.
Yeah.
What will be the fate of the provisional protection application? You
Yeah.
are asking.
Yeah.
That is the point, no, sir. Sir, that will continue. No, both are distinct and different. No, that is for the period from filing of application till registration. Infringement is from the date of registration till the period of protection is completed.
Yeah.
So as you say, when the provisional protection is pending, registration is done, the provisional protection will continue, but it will be only for the period from date of filing
Agree.
application to
Yeah.
this.
So is it clear? Otherwise, we need to propose any clarifications during this amendment of
If
the
you
act.
want to propose, you can propose a clarification.
Yeah, that's what, maybe what I would suggest is you please propose also.
Yes, sir.
So maybe we can include it also, otherwise what Ganesh said.
Legally it will be challenged
absolutely
since you
clear.
got a
From
grant
date
of registration.
From date of filing till grant of certificate.
Yes.
That provisional protection is there.
Yeah.
But still you want, specifically we would include in recommendation.
Thank you.
Anybody else? Tara?
Yeah, very good morning to all. Good afternoon, rather. So I have one question, typically on the enforcement issues, especially, Vaibhav ji has also said that somebody is using our seed and they're packing it, and we have all the fly-by-night operators issue. So I'm coming up on the production point of view also. We have major infringements at the production level. So how do we get to enforce using the IP applications, whether it is under section 24(5) or after the post-registration? So Ganesh said that, in the court we can get from the court. But during the process of our application, what happens is identification of a variety itself takes a lot of time, because the crop period will be, say, for example, 100 to 120 days. So we identify the crop and look at it. It'll be around 80 days or 90 days. So we just have a very short span. How do we protect ourselves when such production misuse happens at the ground level? Second thing is, mostly the production is not a very organized manner. So getting evidences pertaining to production is also becoming a problem. If it is a market side, we get all the evidences, we buy the seed, test it, and do all those things. But in production level is a very, very typical scenario where getting such kind of evidences is also a problem. So what kind of a suggestions you can give us to enforce our IP at that level?
Ma'am, I think your question is, while the application is pending for registration,
Yes.
and production level, if variety is being abused, or rather like infringement it is being abused, it takes 120 days or 90 days, whatever maybe. Then it would not be possible to collect the evidence and submit. Ma'am, see, in this case also what you can do is you can make an application before the registrar to take an inventory and of these materials and compute the extent of the cultivation which is being done.
I'm actually asking you where it is an unorganized system. Usually at the production level, what happens is we are giving to the organizers. So we have our own organizers. We are giving to the organizers. Organizers in turn do the production, and then they give back the seed to us. But sometimes what happens is at the ground level itself, the farmer saves some seeds. That is one problem for us. Or sometimes the organizer saves some seeds, and they themselves start producing it for the next years, and then they push it. So we will not able to realize also, by the time we realize that they have taken up the production, it is almost a very short time where we are left to protect our IP. That is where is a serious concerns which we are seeing now.
So we will pass on this question to Neeti.
This is not a question for Plant Variety Authority. They are there to register, they are going to give you a certificate, and they are going to produce the certificate or help you to give you certified copies of the documents that you have already submitted to go to the court. Your question is practical, where you want to enforce your rights for something you have created on your own. And there is no denying the fact that Indian agricultural industry needs to gear up and become international.
See, I'm not coming up on registration, post-registration.
No, I'm also not going on registration
I'm
right
just
now.
thinking on, if at all we are coming on
yes,
provisional
yes, ma'am.
protection.
So I
situation.
can, if I can, continue. In patents, till 2005, we did not have patents for pharmaceuticals. We had an extensive generic industry, and a lot of medicines were produced in India, both small, big companies everywhere. In coming to agriculture sector, we didn't have plant variety rights. Lot of material was used. So if in pharmaceutical industry, I said that I'm a generic Indian company and I'm selling this product, my name was enough and people would accept it. Same goes for agriculture industry. If you said that yes, my company, an Indian company, is making the seed, people will say yes, it is coming from this company. So everything was going in a gentlemanly fashion. With the introduction of IPR rights in patents, now you cannot produce anybody else's pharmaceutical product or a medicine or a tablet till the time you either have a license or the patent has been expired. If you do, then you will need to go to court. Okay. Same goes, I'm talking from the unorganized sector perspective when you're talking right now, right? When they were earlier copying it, they had no problems. If now they produce it, they know that they can be sued if there is a right existing. So what burden it comes to you? How did the Indian generic industry move into innovations? Now Indian pharmaceutical company has a lot of patents. The unorganized sector is going to move into getting their new varieties registered very soon. So the companies who are currently there need to strengthen their confidentiality. That's very important. Every time you are moving to the unorganized sector, you still need to have that piece of paper in place that the material is going to be confidential and be supplied to you only. It was not going to go to anybody else. So that it's not under the Plant Variety Act, but under the Contract Act that you can take action against them.
That is very true when there is an agreement, a contract. But
Yes.
this is a practical situation, where we have to establish, we are taking a production in the farms.
Yes.
So pilferage from the farms is not in our control at all.
So, but
So
you,
that is,
when you give to the
very-
farmers, you do have an agreement, right?
That is when we are giving.
Right.
If somebody is taking
So that's what? From taking from where?
from the fields, from the
From the
production
fields, then how you're keeping your security? You need to have,
Ma'am,
see, you
it
have
is
to
a-
upgrade yourself to make sure that nothing is stolen from your material is not stolen.
It is not so practically easy. We do it in acres and acres, thousands and lakhs of acres, where not only us, the whole seed industry has this problem. Whether it is NSAI or FSII, all of us have this problem because we do the production in huge acreage. Why we come to PPVFRA authority is that we have a protection of our varieties, and these varieties are provisionally protected from the day I have filed an application. So the day I have a registration, I can run to the court, I can make the court seek some kind of a permission, as Ganesh ji has said, that no, you as some person to get to the field and collect the samples.
But ma'am, when
But
you didn't
here
have,
this
yeah,
scenario
ma'am, but when
doesn't
you
come up.
didn't have the Plant Variety Authority, what would you do?
See, the IP is that right which I am asking.
No,
seeking
I'm
today.
asking you the question that when you didn't have the Plant Variety Authority giving you the right, what did you do?
That day it is not that,
That is not going anywhere. All those remedies are not going anywhere. You can still go under the Contract Act, you can still go under TOS, you can still go for F. Everything is still there, which you were doing still without the plant variety registration.
Neeti, just to interrupt, this is, kind of a sector where it's grown in the field. It's not a manufacturing plant where you can frisk everyone. It's open field, thousands of acres of land. So that's the problem. That's why the IP issues are coming in. So let's hear from Vaibhav also if he is having any view on this.
So, madam, I can understand your point because I have faced it personally. So I met this guy from Tamil Nadu. We have a very famous hybrid, very famous beans called Gomati, which is registered by Government of Maharashtra. And I would really like to congratulate Government of Maharashtra that they are doing a great job in terms of registering the varieties. So this guy met me and he told me that I am buying 2 tons of your Gomti from farmer. Why don't you start selling it to me directly? So I could not do anything because there is no law in place. So what madam is trying to say, can we get some mechanism in place that if I find someone who's stealing my material, madam correct me if I'm wrong, and she can go to the court or to the authorities and say immediately stop him, that he is doing it. So we need to have that mechanism in place. That is what she is asking.
I don't think there's a mechanism as of now, but I can share a strategy which you can use is with respect to the denomination. Because the denomination, if it is, you have not applied for an application, you can use it as a trademark. And that's the reason the authority distinguishes it under section 17, that if you're applying for a variety, the denomination cannot be registered as a trademark. So that's one way, and I completely understand the situation, what you're talking about, because we have a very unorganized sector in India. However, we didn't have intellectual property in India. Now that intellectual property has come into place, we have to become organized. So let's think not now, think 50 years and 100 years from now, that how the systems would change. Only in 20 years we have seen changes because of Patent Act being revised. In plant variety registrations, the awareness has increased a lot. I mean, we have very, very few cases, even though the Act is of 2001 before the courts under the Plant Variety Act. So we are not thinking very short term, ma'am. We completely understand the current situation is very difficult. The United Nations says 128 years more remaining for women to become equal. So after last 200 years of women coming back into force, trying to become a little bit more than property of men. So things are going to change. It's going to take little extra time. It has changed in the Western world. They have become organized for agriculture industry. We need to do that if you want to be a global company or global country from the industry perspective for agriculture.
Yeah, thank you, Neeti. We have shortage of time. So anybody else having any question?
So one point.
So, Surya, just a moment.
Amendments already authority proposed. We are not going into those amendments, sir, which are not an act. Yeah, and then we also formed several committees for each topic. And then we also discussed several things in Hyderabad. Those things I am not asking. Sir, you already started online registration process for certain crops. Now, when we can expect for other crops, which are business important crops? So, this online end-to-end online system.
Of course, when this portal was launched, it was for basically 4 crops. And already we have given, because there are certain technical requirements, and we asked NIC to do it for us. So we have given the list of DOS characters and all. So in first batch, very soon, Chairperson sir has given a target of 2-3 months also, that we are going to get first those 80-90 crops where applications are there. Because of course, as Chairperson was telling that there are 2, not 3 crop species which we have notified, but not in all of them applications are there. So where active applications are there, that we are going to do. And as far as Act Amendment, Act and Rule Amendment is concerned, nothing has yet been finalized. We have not proposed anything. In fact, we are inviting suggestions. So if you have any suggestion, not just for amendment in Act and Rules, for anything, it could be provisional protection, it could be other things. Everywhere we have included some representation from all the stakeholders. So people are there, attorneys are there, seed industry is there, farmers are there, innovators are there. So we have taken everybody on board. So you please provide your suggestion, that is one thing. And as far as the very complicated question of Dr. Tara Madam is concerned, I couldn't fathom it completely, I'm sorry for that. But what I could understand is she, in a way, she wants to preempt, isn't it, when someone is producing itself. And that's what her concern is, that most of the seed production happens to be in unorganized sector. So how at the stage of production itself we can preempt that. Basically, if that is the question, if I could understand. Right. So when you go for the production, why do not you sign contract? Why do not you take that care?
So we do that, sir.
Yeah, that is what. But if you are doing it in organized sector, and then it would be, of course, we are not shying away from our responsibility, but it would still be very difficult for us. It is like I am moving in, on a street, and some shopkeeper coming and saying, catch hold of this man, tonight he is going to get into my shop. So that would be preempting, that kind of thing, maybe a bit difficult, but we are ready. We are ready, and if you can suggest some mechanism,
surely we'll have a look into that.
Sir, there is something like AIB, what they have in Europe. So AIB, that bureau, generally, if such thing happens, what Madam is raising the question, they go and with the help of the police, they raid that particular place.
So what could be mechanism for that? We are open to that. We are not shying away from responsibility. You suggest that mechanism.
Right.
We'll have a look into it and we'll put it up before the committee.
So I
Of
think,
course,
Madam,
yeah,
you
yeah.
have asked the question, you can only
Exactly.
give them
It has
the
to go to
remedy now.
Parliament finally. So you please give your suggestions. We are open to it.
Elsewhere in Africa also, we had recently some meeting in Upau where there was enforcement discussions where some country perspectives were placed for enforcement of IP laws. Probably in that the authorities who are giving the IP rights have also a major role where they hand in hand go along with the government departments like a police or policing authorities to identify such kind of people and get hold of them.
Such mechanism that exists elsewhere and how do they ensure? You please give us a suggestion.
Yes,
No,
we will
we'll
do
go
it.
through it. We'll go through it. We are not denying.
Tara Madam, you submit the proposal.
We are not
Whoever
here
is
to
ready
contest your points. We are ready to
accept
take
it.
suggestions. That's what we work.
Yes.
Anybody else? Because otherwise we will close this session.
No. My question is to Raghavan.
What's your name, please?
This is Lakshman from Namdari 6. My question is to Raghavan. Sir, I understood from your presentation that in IPR law there is a provision for benefit sharing, right? So now we know that BDA rules are coming up, and in BDA also there is a provision for benefit sharing. If the same variety is getting registered under PPVFRA, and then if we are accessing the biological resources from the Indian territory, then we are applicable under BDA also, right? Then we have to pay benefit sharing under BDA as well as under PPVFRA. Then it's a kind of overlapping. That's what I feel you have to give a light on this. And one more question, sir.
Yes, sir.
One more, sorry. Will there be any exemption to the entity who is paying benefit sharing under BDA in PPVFRA for benefit sharing costs? Because it will be like in BDA it is 0.6% up to 0.6% maximum. And here you have mentioned that 0.2% of sale value plus 1% of royalty plus 2,000 annual fee and so on. If that is the case, then these all charges are going to increase the seed rates into the market, which ultimately would put pressure on the farmer's pocket.
This is the annual fee rate, sir. That is for registration. Post registration you have to pay.
Yeah.
As far as benefit sharing, your question, sir, I will say to you, benefit sharing under this biological. See, once you get a right under PPFR Act, it is totally exempted from the purview of Biological Diversity Act. That is clearly mentioned in the newly inserted provision. That is number one. And number two, what I am trying to say is, see, you must, there is a basic distinction between benefit sharing under Biological Diversity Act and benefit sharing under PPFR Act. There it is done administratively. So whatever you are going to take the biological resources, you have to execute an agreement with them and you are paying. Here it is a judicial proceeding. It has to be filed within 6 months from the date of advertisement of the registered variety in the journal. So thereafter another 6 months authority can extend. So after 1 year from the date of registration for benefit sharing cannot be filed. So it is a judicial proceeding. It is for if the claim for benefit sharing is not filed, then it cannot be filed thereafter. Okay. So even assuming as this first case, what you say, if benefit sharing you are paying there, and here again the same party files a claim before the authority. As I told you earlier, it is a judicial proceeding. If the benefit sharing before authority NBA is submitted before the PPFR authority, it will naturally take it into consideration, pass order accordingly. Because that this is a judicial proceeding, you can submit the order very well here. So that can be done.
Just one from biodiversity. So under the Biodiversity Act, agriculture conventional breeding is exempted. So for if you're doing conventional agricultural breeding, is it completely exempted?
I'm talking about the commercial utilization of the
Commercial utilization, as long as it is for your
benefit sharing under BDA is applicable for commercial utilization.
commercial utilization of the, if it is utilized as an agricultural product, it is exempted. That's what I'm telling you, sir. It is also exempted if it is a normally traded as commodity as well. Further,
But
the IPTGRFA annexed one list Those crops are also fully exempted. They do not come under the Biodiversity Act.
But it's not clear about commercial hybrid which we are selling into the market, right? So,
Commercial hybrid conventional breeding, sir? Yeah. Exempted. Please don't go to the Biodiversity Authority.
Once it is registered, it is totally exempted. Even though your application.
No, I'm saying even if you're not registered.
Not registered
it is
also.
exempted under the Biodiversity Act. Please don't go for any.
Madam is saying even if it is not registered, one step forward you are saying
Yes.
that as a NPC,
Not even NPC. Under the definition of commercialization, there's exemption on conventional breeding and agriculture.
Sir,
Thank
the
you.
question is, that's a different debate what she is saying. I'm not going into it. But let's say we had the NB approval for access and then we also applied to PPVFRA authority for IP rights. And in the meantime, let's say the variety also commercialized. So now I think the question is like we are paying to, as per the ABS, we are paying to NBA. And now since registered in under PPVFRA, so we have to pay annual fee. So it's a kind of a double taxation for a particular variety or hybrid. So whether we have to continue to pay both the authorities or harmonization can be possible, in future.
I think harmonization a little bit it would be difficult because our law says, the PPFR law says that every registered breeder is bound to pay annual fee based on the benefit or royalty gained by him. That's what section 35 says. If you have any amendment in it, you can suggest it. So accordingly we'll make it. But as of now, law as it stands says this only. And Biological Diversity Act benefit sharing is totally under a different provision. So we can't say both are. PPFR, yes, that's what I'm saying. I told you earlier because now the current amendment has made it very clear because we have argued with them and we have insisted and they have inserted the provision specifically that the right obtained under the plant variety law is totally exempted from their purview. And apart from it, what Madam says also, it is even without it is also it is exempted. So I don't think so.
I think that's a different forum where we have to include both PVP and this is the last question.
Here in this point regarding Biological Diversity Act, I believe the material we are taking is not what we are filing under PPVFRA. The material that is accessed is different from what we are filing for PPVFRA. So what we have actually created is exempted under the law, but what we are taking is something that we might have to, we are paying benefit sharing form. But yes, under PPVFRA also there is a benefit sharing clauses there. So if that has been done, then I think it's a double time that we are paying. Yeah, and apart from that, I have a question regarding extent variety, the timeline extension for extent variety. I just wanted to understand what is the rationale behind it because it is a good thing, if it were, my personal view is couple of years were good, but for certain crops which are open for a long time, giving a 10 years, timeline extra, just wanted to understand the PPVFRA's, rationale behind it.
Sir, actually there is a specific provision in section 15 of the Act which says that extant varieties must be registered within a specified time limit, and under the Act the time limit can be determined by the authority, and authority under the specific rule has decided that from the date of publication in Plant Variety Journal of India it will be 10 years. That is the current decision, and so practically speaking all the crops are now open for registration and not even a single crop species under extant variety registration is closed due to the lapse of time limit. So, but that is a provision in the Act. Sir, you want to say something, sir? No.
So, when we extended the time limit, that window by 10 years for the extant varieties, there are 3 categories. The very first category is varieties notified under Seed Act 1966. The other one, the varieties which are in common knowledge, and third one is farmers' varieties. So when we came up with this legislation in 2001, it was understood that within 10 years, whatever is in existence would be registered. But you would know, considering the huge size of our country, so much of variability is there in terms of information, and that is one thing. So it is very difficult to believe that farmers within 10 years, whatever is existing with them, they would register. That is one. Secondly, still in our country, for many crops which are very important for country's food and nutritional security, there are still varieties are being given by public sector, isn't it? And there is a provision in our act that varieties which are notified under Seed Act, they would be registered under this category only. So we have to make a change. So the varieties which are notified also can be registered as under new category. Once we do it, probably there would not be any requirement. But till that requirement is there, that compulsion is there. And considering again the farmers, there is so much of, there are states where farmers are well aware of things. There are, like this morning I was telling you, from Maharashtra there are hardly 210 applications for farmers variety. It doesn't mean only that much of agrobiodiversity is there in Maharashtra. So still we have to cover a big ground, that is one thing. But as far as one subcategory is concerned, that varieties of common knowledge, for that probably it should not be prolonged. Once we notify a species, probably for variety of common knowledge, for them it should only be 10 years. But the thing was, all three, they befall under one particular category, that is the extra notified variety. So now we are going to take care. This is a very good question. I wanted to tell you. For public sector varieties, it is required. For farmers varieties, it is required. But for varieties of common knowledge, for which probably you also might be a beneficiary, you are still getting a chance to register those. So definitely we are going to address it. Thank you.
Lunch is waiting, so I think we can reserve the questions. You can email to me. I hope all of you have my email address. With this, thank you, Nitin, for the conducting a very beautiful discussion. It's time to honor our guests on dais with a small token of remembrance. I request Dr. Nitin Joshi to kindly extend a memento to Mr. D.S. Raja Ganesh. Do we have Dr. Manisha Negi here? Yeah. I request Manisha Negi to kindly extend memento to Dr. Neeti Wilson. Dr. Neeti Wilson. Now I request Mr. Rahul Pagar to kindly give a memento to Mr. Vaibhav Kashikar. Please stay here, Rahulji. I request you to kindly extend memento to Dr. Nitin Joshi also. It is a pleasure for us to have Dr. K.V. Prasad, Director, ICR, Directorate of Floriculture Research, Government of India. I request Surya to kindly hand over a small memento to Dr. Prasad. So we would like to hear a few words from you, if you want to share.
Thank you so much for this wonderful opportunity. I was very keenly listening to the discussions. We were all talking about the seed and related aspects. Of course, seeds are there even in ornamentals, but for us, the maximum infringement happens in the vegetatively propagated propagules that we handle. Across all the IPR regimes, whether it is CPVO, UPOV, or plant patents under USPTO, the maximum number of titles that are in force, that are applied, that are granted, are from ornamentals across all the IPR regimes, except for China. So we would like to be part of such discussions so that at least in case of seeds, you have control over your parents. In case of ornamentals, it is not there. Once it crosses my hands, the material is open for anybody to photocopy it. So that is happening across all the IPR regimes, whether it is in India or abroad. Here it is more so because the material here, the contrast that I could see is you have the industry has their own varieties. In case of ornamentals, we are getting many things from the outside, which are being propagated, which is the major problem for the floriculture industry to take forward. We have a discussion in the afternoon, a similar kind of a discussion which we are going to rush through. Thank you very much for this opportunity.
Thank you, Dr. Prasad. With this, we come to the closure of the session. We have senior colleagues from the Government of Maharashtra. I request Surya to kindly hand over a small memento to Dr. Mr. Nitin Fulsundar. It's time to recognize their contribution, their support. Thank you, Mr. Fulsundar. I request Nitin to kindly hand over a small memento to Dr. Preeti Savairam from the Department of Agriculture, Maharashtra. Thank you, madam. With this, we come to the close of this session. The discussion which was earlier planned with the Department of Agriculture, Maharashtra, we will keep it for some other time because we wanted participation of some of the senior officers here, but because of their some urgent matters, they were not able to make it to this program. So we will plan it maybe in the next month or after that at a suitable time. So with this, we come to the close of the session. Thank you so much to you all